You know how sometimes you just need the short version of something really important, something that feels incredibly dense, like trying to make sense of a huge law without, well, spending weeks buried in books.
Absolutely. It can feel overwhelming.
Well, you've come to the right place today. We're doing a direct dive into a really crucial piece of legislation. It impacts a massive number of workplaces and employees right here in India, the Employees Provident Funds and Miscellaneous Provisions Act, 1952.
Exactly. And think of this deep dive as your shortcut. We've gone through the actual text of the act to pull out the core stuff, the things you really need to grasp. This law is basically the foundation for provident funds, pension funds, and even that deposit-linked insurance for employees in so many companies.
It really is fundamental Social Security stuff.
It is a key part of the puzzle.
So our mission today really is to make this act make sense for you. We want to pull out the key ideas, the essential rules, and how it actually affects both employers and employees, all without getting lost in the legal jargon. Consider this your faster route to understanding.
A clear pathway through the details.
Right. So where do we even start unpacking something this significant?
The most logical place is usually Section 1 right at the beginning. It gives a short title, where it applies, and who it applies to. So the full name. The Employees Provident Funds and Miscellaneous Provisions Act, 1952. Came into force way back then.
1952. Okay, basics down. Now, geographically, where does this law hold sway? Does it cover all of India?
It does now, yes. It extends to the whole of India. It's worth remembering that historically, Jammu and Kashmir was excluded, but that changed. So now it definitely covers the Union territories of Jammu and Kashmir and Ladakh too.
Okay, good clarification. That confirms its current nationwide reach. Now, thinking about workplaces, what kind of places does this act cover? Is it every single shop and office?
Not quite every single one. Generally, the rule of thumb is it applies to establishments employing 20 or more persons.
20 or more, okay.
But, and this is important, the central government can issue notifications to bring smaller places under the act too. And even if a company has fewer than 20, the employer and most of the employees can actually agree voluntarily to be covered.
So there's some flexibility there. It's not strictly 20 plus or nothing.
Exactly. There's the standard rule, but also ways for smaller groups to be included.
And who's actually in charge of overseeing this? Is it one big central body making sure everyone follows the rules?
It's actually a bit more divided than that. It depends on the type of establishment. For those run or controlled by the central government, like think railways, major ports, mines, oil fields, certain big industries, or companies with branches in multiple states, the central government is the controlling authority.
Okay, the big players.
Right. But for all other establishments within a specific state, it's the state government that takes on that role.
Got it. So it's tailored depending on the employer's scope. Now, like any law, this one has its own language, right? Section 2 is full of definitions. These seem pretty crucial for understanding everything else. Can we break down a few key ones?
Absolutely. Let's start with authorized officer. This basically refers to the key administrative people, the Central Provident Fund Commissioner, and then the additional deputy and regional commissioners, plus any other officer the central government might officially appoint. These are the folks with the power to administer and enforce the act.
The key personnel. Okay, what about basic wages? That sounds fundamental.
It really is. Basic wages covers all the money an employee earns for their work while on duty or during paid leave or holidays as per their contract. But crucially, you need to know what it doesn't include.
The exclusions.
Yeah.
The act specifically excludes the cash value of things like food concessions, house rent allowance, any overtime pay, bonuses, commissions, and importantly, the employer's own contributions to pensions, provident funds, or insurance. So it's the core salary stripping away the extras and the employer's fund contributions. Makes sense.
Exactly. It's a very specific definition.
Next up, employer. Seems obvious, but does the act define it in any particular way? Any surprises there?
Well, it's defined quite broadly, which is important for coverage. It obviously includes the owner or occupier of a factory, but it also covers their agents, legal representatives if the owner passes away, the factory manager.
Standard stuff so far.
But here's the key part. It also includes anyone who employs people through a contractor. And it includes apprentices too, though there's an exception for those under the Specific Apprentices Act of 1961.
Oh, interesting. Including employers using contractors is a big deal for many workers.
It is. It ensures those arrangements don't fall through the cracks.
Definitely. Okay, there's a list of other terms here in Section 2. Maybe a quick rundown. Exempted employee, fund, insurance scheme, pension scheme prescribed, recovery officer, scheme, superannuation, and tribunal. Just the gist of each.
Sure, let's do a quick glossary. An exempted employee is someone who normally be covered but gets an exemption, usually because they have comparable benefits already. We'll touch on exemptions later.
Okay.
The fund, that usually means the main employee's provident fund scheme, the big savings pot. Insurance scheme refers to the employee's deposit-linked insurance scheme. That's the life insurance part.
Got it.
Pension scheme is the employee's pension scheme for retirement income and other situations. Prescribed just means as set out in the rules made under this act.
Standard legal term.
Yeah. A recovery officer is someone empowered to collect overdue money. Scheme typically defaults to the main provident fund scheme. Superannuation, specifically for the pension scheme, means hitting age 58. And the tribunal is the industrial tribunal, basically the appeal body for disputes under this act.
That's super helpful. A mini dictionary for the act. Okay, now let's get into the structure. How is this all set up and run? Sections 5 through 5E cover this, right?
Right. Section 5 is the starting point for the structure. It mandates setting up the employee's provident fund scheme and creating the actual fund. And the key thing, the fund is vested in, meaning owned and controlled by and administered by the Central Board of Trustees.
The central board. So they're the main governing body.
Exactly. They're the key decision makers.
And who's on this board? Who gets a seat at the table?
Section 5A spells that out. You have a chairman and a vice chairman appointed by the central government. Then you have officials representing the central government, representatives of employers chosen after talking to employer groups and representatives of employees, chosen similarly after consulting employee organizations.
So, government, employers,
Yeah.
employees, a tripartite structure. Seems balanced.
That's the intention, yes, to bring all the main stakeholders together.
What about the day-to-day operations? Does the full central board handle everything?
Not every single detail. That's where the executive committee comes in, set up under Section 5AA. It's designed to help the central board manage its functions more effectively. Think of it as the operational arm.
Okay.
And Section 5B also allows for state boards to be set up, which handle similar functions but at the state level for establishments under their jurisdiction.
And these boards, are they just advisory committees or do they have real legal power?
Oh, they have real standing. Section 5C is clear. Every board of trustees, like the central board, is a body corporate. That means it's a legal entity in its own right. It can own property, make contracts, sue people, be sued. It's not just a group of individuals.
Right, like a company or organization in legal terms. So they have clout. What about the staff who actually do the administrative work, the commissioners and others? How are they appointed?
Section 5D covers that. The central board appoints its officers and staff. But for the top jobs, the central PF commissioner, additional commissioners, the financial advisor and chief accounts officer, other senior roles, the board must consult with the UPSC, the Union Public Service Commission.
UPSC involvement. Okay, that adds a layer of formal process.
It does. There are exceptions for short-term posts or internal promotions, but generally, consultation is required for those key positions. State boards appoint their staff too, but they need their state government's approval.
So clear procedures there. Now, what if, say, there's a vacancy on the board or maybe some minor technical issue in how it was formed? Does that stop everything or invalidate their decisions?
Good question. Section 5DD actually prevents that. It says that no act or proceeding of the Central Board, Executive Committee, or State Board can be questioned just because there was a vacancy or some small defect in its constitution. It keeps things running smoothly.
A practical safeguard against bureaucratic hiccups. Makes sense. And lastly, on administration, can these boards delegate tasks?
Yes, Section 5E allows them to. Both central and state boards can delegate powers and functions to their executive committees, their chairpersons, or other officers. They can set conditions, of course. It's about efficient workflow.
Okay, administration covered. Let's switch to the money contributions. Section 6. This is about how much goes into the fund. What are the standard rates?
The standard rate, laid out in Section 6, is 10% of the basic wages plus dearness allowance and retaining allowance. We defined basic wages earlier. And that's 10% from the employer, and 10% from the employee.
10 plus 10. Okay.
So for every 100 rupees of that defined pay base, 10 comes from the employee's pocket, and the employer matches it with another 10.
You said standard rate. Does that mean it can be different sometimes?
Yes, exactly. There's a provision allowing the central government to specify a higher rate, 12%, for certain types of establishments. They do this after an inquiry looking at the company's financial health and other factors.
So some industries might pay 12 plus 12.
Correct.
What if an employee wants to save more? Can they put in more than the required 10 or 12%?
Absolutely. Employees can choose to contribute more than the statutory rate. But, and this is key, the employer is only obligated to match up to the statutory rate, whether that's 10 or 12%. They don't have to match any extra voluntary contributions from the employee.
Got it. It's an option for employees to boost their own savings. Good to know. You mentioned dearness allowance and retaining allowance again. Can we just quickly nail down what those are?
Sure. Dearness allowance, or DA, is basically a cost of living adjustment. It's paid to employees to offset inflation. Retaining allowance is something paid usually in seasonal industries or factories during the off-season or shutdown periods to keep skilled workers on the books, ready for when work resumes.
Okay, that helps define the base for contributions. Now, this act is more than just the Provident Fund, as we said. Pensions and insurance come in too, Sections 6A and 6C. Let's look at the pension scheme first. What's its main purpose?
Section 6A sets up the employee's pension scheme. Its goal is broader than just savings. It's about providing long-term income security. It covers pensions for superannuation that's reaching retirement age, usually 58 or earlier retirement, permanent total disability, and also survivor benefits like pensions for widows, widowers, children, and orphans.
So a much wider safety net.
Definitely. It's a crucial Social Security element.
How is this pension scheme funded? Where does the money come from? Is it separate?
Yes, there's a separate pension fund. A big chunk of its funding actually comes from diverting part of the employer's contribution to the Provident Fund. Up to 8.33% of the wage base gets redirected into the pension fund.
Ah, so it's carved out of the employer's PF share.
Largely, yes. Plus, employers of exempted establishments also contribute. And the assets from the old, now defunct family pension scheme were rolled into it. The central government can also chip in with Parliament's okay.
You mentioned the old family pension scheme. What happened to people already getting benefits from that? Were they just cut off?
Oh no, absolutely not. Section 6A3 makes that very clear. When the new pension scheme started, the old one stopped, and its assets and liabilities were transferred. But it explicitly guarantees that existing beneficiaries would continue to get their pensions from the new fund, and the amount wouldn't be less than what they were getting before.
That's really important. A smooth transition for existing pensioners.
Critical, yes. Continuity of benefits was ensured.
And who manages this pension fund? Same people.
Yes, just like the Provident Fund, the pension fund is also vested in and administered by the Central Board of Trustees. Same oversight body for both.
Okay. Now, Section 6C, the Employees Deposit-Linked Insurance Scheme, or EDLI, what kind of protection is this?
This is essentially a life insurance component tied to the PF membership. If an employee unfortunately passes away while in service, their nominee or legal heir gets a lump sum payment. The amount is linked to the employee's average PF balance over a certain period.
A life insurance benefit, okay. And how's this funded? Do employees pay for this too?
No, typically employees don't contribute directly to this one. There's a separate deposit-linked insurance fund, and it's primarily funded by the employer's contribution. The employer pays an amount, usually around 0.5% currently, though the Act allows up to 1% of the total wage bill, basic plus DA plus retaining allowance.
So mainly employer-funded life cover, another layer of security.
Exactly, an additional benefit for the employee's family.
Now, things change over time. These schemes probably need updating. Section 7 talks about modifying them. How does that work?
Section 7 gives the central government the power to add to, amend, or vary the schemes. PF, pension, insurance. They do this by publishing notifications. And these changes can be prospective, meaning for the future, or even retrospective, applying to the past.
Retrospective changes, can they just change the rules backwards without checks?
Well, there is a crucial check. Section 7 requires that every notification making these changes must be laid before both houses of Parliament as soon as possible. Parliament can then review it, suggest modifications, or even annul the notification.
Parliamentary oversight, that's important. So it's not just an executive decision.
Correct. There's a layer of legislative review.
Okay. Now, what about disputes? What if an employer isn't paying the right amount or disagrees if the act even applies to them? Section 7A seems to cover determining the money due.
Right. Section 7A gives the Provident Fund Commissioner central, additional deputy, regional assistant the authority to investigate and decide two main things. First, whether the act applies to an establishment at all, and second, to determine the exact amount of money due from an employer under the act or the schemes. They can conduct inquiries to figure this out.
Inquiries? What kind of powers do these officers have during these investigations? Are they like investigators?
They have significant powers, actually very much like a civil court, for the purpose of the inquiry. They can summon people and examine them under oath, force the production of documents, accept evidence via affidavits, and even set up commissions to examine witnesses. These proceedings are considered judicial under the Penal Code.
So they have real teeth to get information. Does the employer get a say before a decision is made?
Absolutely. Natural justice is built in. Section 7A3 explicitly requires that the employer must be given a reasonable opportunity to present their case before any order determining the amount due is passed.
Fair hearing. Good.
And there's more. Section 7B allows employers to apply for review of that order under certain conditions, like finding important new evidence they couldn't produce earlier, or if there's an obvious mistake in the order itself.
Okay, so avenues for appeal or review exist. What if some money owed was missed in the first place? Section 7C, determining escaped amounts.
Yes, if an officer believes, based on information, that some amount due for a period wasn't assessed initially, maybe the employer didn't disclose something, or even if it was just an oversight, they can reopen the case and reassess the amount. But there's a time limit, 5 years from the date of the original order. And again, the employer must get a fair hearing before the new determination.
A 5-year window to catch missed amounts, but still with due process. Okay, so once it's decided an employer owes money, how does the system actually collect it? Sections 8 through 8G deal with recovery.
Right. Section 8 first lists what can be recovered.
Yeah.
Unpaid contributions, damages, which are penalties for default, accumulations that need transferring, other charges, basically anything payable. If these become overdue, they're considered arrears.
Arrears, okay.
Then, sections 8B to 8G outline how these arrears are recovered. A key step under 8B is the authorized officer issuing a recovery certificate to a specific recovery officer. This certificate states the amount due and who owes it.
Like a formal demand notice with legal backing.
Exactly. And Section 8D says this certificate is valid across India. The recovery officer then takes steps.
What steps can the recovery officer take? What powers do they have?
Section 8C says they recover the amount basically as if it were an arrear of land revenue, which historically gives strong collection powers. Section 8F details other methods too. They can order someone who owes money to the defaulting employer to pay the PF department directly instead. They can issue notices to banks holding the employer's money, ordering payment. They can even apply to a court holding the employer's funds.
Wow, quite a few ways to get the money. Attach bank accounts, intercept payments.
Yes, the aim is effective recovery. And Section 8G brings in parts of the Income Tax Act's recovery procedures, specifically the second and third schedules and related rules. This provides a ready-made, detailed framework for things like attachment and sale of property.
So they leverage the established tax recovery mechanisms. Smart. Now, what about contractors? If a main employer pays contributions for workers hired through a contractor, can they get that money back from the contractor? Section 8A.
Yes, Section 8A clarifies this. If the principal employer pays the contribution for a contractor's employee, they have the right to recover that amount from the contractor, maybe by deducting it from payments owed to the contractor.
Makes sense.
And then the contractor, having had that amount recovered, can deduct the employee's share of the contribution from the employee's wages. But crucially, the contractor cannot deduct the employer's share or any associated charges from the employee's pay.
Right, so the worker only pays their own share, not the employer's part, even indirectly through the contractor. That's a vital protection.
Absolutely. Protects the employee's wages.
Let's think about tough times for businesses. Insolvency, winding up. Section 11 talks about priority of payment. Where do EPF dues stand when a company goes bust?
This is incredibly important for employees. Section 11 gives EPF dues super priority. If an employer goes insolvent or a company is wound up, any amount due under the Act Contributions, damages, charges that accrued before the insolvency order or winding up started gets paid out before most other debts.
Priority debt status. Okay.
But it goes further. Subsection 2 declares that any amount due under this act is the first charge on the assets of the establishment. This means it ranks above almost everything else, even secured creditors in many cases, regardless of other laws. It's top of the list.
First charge. That's powerful. Ensures the employee's fund gets paid first if possible.
It provides very strong protection for those dues.
On a related note, protection for the employee's balance itself. Section 10, protection against attachment. What does this mean?
This is another critical safeguard. Section 10 says the money sitting in an employee's PF account, or an exempted employee's fund, cannot be assigned, charged, or attached by any court order for any debt or liability the employee might have.
For creditors can't touch it.
Exactly. It's protected. This protection extends to nominees who receive the funds after the member's death. They receive it free from debts the deceased had, or even debts the nominee had before receiving the money. It also covers family pension and insurance scheme payouts. It ring-fences these benefits.
Keeps the Social Security funds safe for their intended purpose. Vital. Okay, what about enforcement beyond recovery? Penalties for breaking the rules. Section 14.
Section 14 outlines penalties. Making false statements to avoid payment can lead to imprisonment up to a year, or a fine, or both. But there are much stiffer penalties specifically for employers who default on contributions.
Harsher for non-payment.
Yes, especially if they've deducted the employee's share from wages, but haven't deposited it. The law distinguishes between failing to pay the employer's share and failing to deposit money already deducted from employees. The latter is treated more severely, with mandatory minimum imprisonment terms in some cases. There are also specific penalties for violating the insurance scheme rules and general penalties for other contraventions.
What about companies? If a company breaks the law, are the managers or directors responsible?
Yes, Section 14A covers offenses by companies. It says if a company commits an offense, every person in charge and responsible for the business at that time is also deemed guilty, unless they can prove they didn't know or they exercised due diligence to prevent it.
So, personal liability for those in charge?
Potentially, yes. And if the offense happened with the consent or negligence of a director, manager, secretary, etc., they're also personally liable. Section 14A adds even tougher penalties for repeat offenses of non-payment of contributions, potentially up to 5 years imprisonment and a hefty fine.
Serious consequences for non-compliance, especially repeated non-compliance. Are these offenses things the police can investigate directly? Like, are they cognizable?
Section 14AB states that offenses related to non-payment of contributions are cognizable. So yes, police can investigate without a warrant. However, Section 14AC adds a procedural step for prosecution. A court can only take cognizance based on a written report of the facts, made with the prior sanction of the Central PF Commissioner, or authorized officer, and submitted by an inspector.
So investigation is possible, but formal court action requires specific sanction and reporting.
Correct. A check in the process before prosecution begins.
Okay. Now, are there situations where this act just doesn't apply at all? Exemptions? Section 16 lists some.
Yes. Section 16(1) carves out some automatic exemptions. Certain cooperative societies employing fewer than 50 people without power are exempt. Also, government establishments, central or state, whose employees already have comparable PF or pension benefits under government rules, and establishments set up under specific acts that provide similar benefits. The idea is to avoid duplication where good systems are already in place.
Avoids overlapping schemes. Can the government grant other exemptions, maybe for specific industries or companies facing difficulties?
Yes. Section 16(2) allows the central government to exempt classes of establishments based on their financial position or other circumstances via notification. And Section 17 provides a detailed mechanism for granting exemptions to specific establishments or employees, usually if they prove they have comparable or better benefits, like their own PF trust, pension, or gratuity scheme. This usually involves consultation with the central board to ensure employee interests aren't compromised.
So case-by-case exemptions are possible if benefits are comparable. What do these exempted places still have to do? They're not totally off the hook, right?
Definitely not. Section 17A lists their obligations. Exempted establishments still need to maintain proper accounts, submit returns, invest their funds as directed by the government, allow inspections, and pay inspection charges. They are still supervised.
They operate their own scheme, but under oversight.
Exactly. And Section 17AA clarifies this act overrides anything conflicting in the LIC Act. Section 17B is also important if an establishment is transferred. Both the old owner and the new owner are jointly liable for any dues unpaid before the transfer.
Prevents washing away liabilities through a sale. Good point. How is all this monitored?
Yeah.
Section 13, inspectors, what's their role?
Section 13 provides for inspectors appointed by the government.
Sure.
Their job is to check if the information provided is correct and if the act and schemes are being followed. They have powers to demand information, enter premises, inspect records, examine people, employers, agents, employees, and even seize documents if they suspect an offense.
The enforcement arm on the ground.
Pretty much. And Section 18A clarifies that these inspectors and the commissioners acting under Section 7 are considered public servants under the law, giving them certain legal protections and duties.
Okay, we're getting near the end of the Act's main structure. Just a few final sections. Delegation 19, Government Directions 20, Rulemaking 21, and Removing Difficulties 22. Quick summary.
Sure. Section 19 allows the government, central or state, to delegate its powers under the Act to subordinate officers. Section 20 gives the central government power to issue binding directions to the Central Board on policy matters for efficient administration.
Top-down direction is possible.
Yes. Section 21 gives the central government the power to make detailed rules for implementing the Act, like procedures for appeals, recovery certificates, etc. Crucially, these rules must be laid before Parliament.
Parliament gets to see the rules too.
And Section 22 was a temporary power, initially for 3 years after the 1988 amendments, for the central government to issue orders to resolve any practical difficulties in implementing the amended Act, with those orders also needing parliamentary review.
A mechanism to smooth out initial implementation issues. And the schedules mentioned at the end, what's in those?
The schedules provide the nitty-gritty details. Schedule I lists the industries the Act applies to. Schedules 2, 3, and 4 list the specific matters that can be covered in detail within the PF scheme, the pension scheme, and the insurance scheme, respectively. They flesh out the framework provided in the main Act.
The fine print, essentially.
In a way, yes. The detailed operational aspects.
Okay, that was a really thorough journey through the EPF Act of 1952. So for you listening, the big takeaways are: this act provides a vital Social Security framework through the Mandatory Provident Fund, the pension scheme for longer-term security, and the deposit-linked insurance. It sets out clear duties for employers and rights for employees.
And it establishes the whole administrative machinery. The boards, the officers, the rule for contributions, recovery, penalties, and dispute resolution. We've tried to cover all those key pillars today.
Yeah, and thinking back, some points really stand out, like that high priority given to EPF dues if a company fails. That's huge protection.
It is. And the protection of the PF balance itself from creditors that Section 10 point really emphasizes its role purely as Social Security, not just general savings accessible to anyone.
Absolutely. Understanding this act is just so fundamental if you're working or employing people in India. It touches so many lives and businesses. It's a cornerstone of employee welfare.
And hopefully this deep dive gives you, our listener, a really solid grounding. You might now want to explore, say, the exact calculations for the pension, or the specific process for claiming PF, or maybe the finer points of getting an exemption. This overview should be a strong foundation for that.
Definitely provides that base. And maybe a final thought to leave you with. In our modern economy, with gig work, contract roles, constant change, how does a 1952 act like this continue to stay relevant? How might it need to evolve to keep protecting India's workforce effectively in the future?
That's the big question, isn't it? Adapting these foundational Social Security systems to new realities of work is a constant challenge, something to ponder.
Welcome to the deep dive. You're here because, well, you need to get the important stuff. fast without getting totally lost in the details.
Exactly.
Today, we're tackling a really significant one, the Employees Provident Fund Scheme, 1952. We've got some great source material bits from the scheme itself, plus some helpful summaries.
Right.
Our mission, basically, is to pull out the core elements, who it covers, how it's managed, the contribution side, and, crucially, how members like you can actually get access to those funds.
Yep. Think of us as your filter. We're wading through the documents so you get the clear picture, the essentials of how this EPF scheme works.
Okay, sounds good. So let's kick things off with the big picture. Who does this scheme actually apply to? It feels like it casts a pretty wide net.
It really does. Generally, as paragraph 3 lays it out, the scheme hits most factories and establishments under the main EPF Act from 52. Think of it like the bedrock for industries back then.
Supporting the workforce in a newly independent India.
Precisely. But like any big system, there were some initial exceptions.
Yeah, I saw tea factories in Assam mentioned specifically, and there was a tossed in the text, maybe hinting at others.
That's right. That suggests there might have been other early exclusions. But the main thrust was this phased rollout across key industries. And that's where you really see how it, grew over time.
Absolutely. It wasn't like flipping a switch overnight. That first wave, September 1952, hit some really core parts of the economy.
It did. September 2nd, 52. That was the start date for cement, cigarettes, the whole engineering sector, electrical, mechanical, general, you name it.
Iron and steel, too. Paper, textile.
All kinds of textiles, yeah. Cotton, wool, jute, silk. It gives you a real feel for the industrial backbone they were aiming for initially.
And it didn't stop there, did it? We saw dates popping up later on. Plantations, for instance, which felt a bit different.
Yes, the scope really widened over the years, adapting as the economy changed. Plantations, coffee, rubber, cardamom, pepper, but still excluding Assam tea. They came in around April 1957.
And industrial gases around the same time. Oxygen and the like.
That's right, July 57. It shows how it was expanding into different economic areas. Mines, too, by the end of 57.
It's quite a historical footprint. Then you jump into the 60s and it gets even more diverse. Starch,
Yeah.
leather, even hotels.
Exactly. Starch in May 61, then leather and leather products shortly after. And hotels and restaurants by June 61. It shows this ambition to cover more than just traditional factory jobs.
Now, it wasn't just those older sectors. It looks like the scheme kept up, bringing in banks and even, IT companies much later.
And that's a really crucial point about its adaptability. Banks with 20 or more people were included, focusing on employees without similar benefits. Then fast forward, 2006, you see IT-related firms brought in under a specific notification, SO1190.
July 27th, 2006. Wow, keeping pace with the modern economy.
It had to. And even local government bodies weren't left out.
Municipal councils, corporations, based on the Constitution.
Yes, Article 243Q is referenced.
Yeah.
So it really aimed for broad coverage across different types of employment, a scheme that's definitely evolved.
Okay, massive scope, covers lots of people. But who's actually running the show? We saw mentions of boards and committees.
Yeah, there's a proper structure. You've got the Central Board of Trustees at the top, then regional committees. And paragraph 8 is interesting. It spells out who can't be a trustee or committee member. It's about accountability.
Right, things like being of unsound mind, insolvent, having a conviction for moral turpitude.
Yeah.
Makes sense. And also employers who haven't paid their contributions.
Exactly. If an employer, even one exempt from the main scheme, hasn't paid their dues to the fund or the board, they're disqualified. It really highlights that employer responsibility.
And these boards and committees, they need to make decisions. There are rules for that too.
Oh yes. Paragraph 11 says the Central Board and regional committees have to meet at least twice a financial year. The Executive Committee, even more, 4 times.
And they need proper notice, like 15 days.
Generally, yes. Paragraph 12 specifies 15 days notice with the agenda. And paragraph 16 stresses keeping minutes a permanent record of what was decided.
And I noticed paragraph 17 says that even if there's a vacancy on a regional committee, or maybe a slight issue in how it was set up, their decisions still stand. That sounds quite practical.
It is. It ensures the committee's work isn't just stopped because of minor technical issues. Keeps the wheels turning.
Now, attending these meetings must involve some time and maybe travel. Do the trustees and members get allowances?
They do. Paragraph 18 covers fees and allowances. Official members get their standard government travel allowances. Non-officials have specific rates depending on where they live relative to the meeting place.
And special rules for MPs or state legislators.
Yeah, ensures their allowances line up with what they'd get in their legislative roles. Keeps things consistent.
We also saw key admin roles mentioned: Central Provident Fund Commissioner, Financial Advisor, Chief Accounts Officer. Seems like they have limits on doing other work.
That's right, paragraph 19. They need central government approval to take on outside work. Ensures they're focused solely on managing the fund.
And to manage things locally, they need offices everywhere, presumably, regional, local ones.
Absolutely. Paragraph 21 gives the central board the power to set up regional and local offices as needed. They define what those offices do.
And the commissioners running these have specific powers.
Yes, paragraph 24 outlines their administrative and financial powers, but always within the limits set by the central board. So there's a clear chain of command.
Okay, scheme set up, management's in place. Let's get to the part most people are keen on: joining the scheme and how contributions work.
Right, paragraph 26 is key here. Basically, every employee in a covered place has to join. Unless they're an excluded employee, which is a specific definition, often based on wages or other factors.
And this applies from day one.
From the day the scheme applies to that specific establishment, yes. And it includes people who might have already been in a company provident fund before the main scheme kicked in for them.
And once you're a member, you stay a member. Paragraph 26A talked about that.
Pretty much. Your membership continues until you either withdraw everything under the final settlement rules in paragraph 69 or you get an exemption.
But there was a point about claiming a refund.
Yes. If you claim a specific type of refund under paragraph 692, your membership is considered terminated once that payment is approved. It's a specific edge case.
And if there's any doubt about whether someone should be a member or when they joined,
that's where paragraph 26B comes in. The Regional Provident Fund Commissioner decides. But crucially, they have to hear from both the employer and the employee first. Both sides get a say.
Fair enough. Now, contributions. We know employees pay a bit, employers match it. But what about people earning, say, much higher salaries? Is there a cap?
Yes, paragraph 26 again. The contribution rates themselves are elsewhere. We saw about 10% each mentioned in paragraph 29. But for calculating those contributions, there's a wage ceiling. The documents mention 15,000 rupees.
So even if you earn more?
Even if you earn, say, 20,000 or 30,000, your contribution and your employer's matching part is calculated only on that 15,000 rupee amount. That includes basic pay, dearness allowance, retaining allowance, if any, and the cash value of food concessions.
Got it. Okay, that clarifies joining and contributions. Now, the really practical stuff, getting money out, withdrawals, advances. When can you access these funds?
This is a big section starting around paragraph 68B. It covers various situations where you might need to dip into your PF savings. Housing is a major one.
Right, buying or building a house. Paragraph 68B, what are the basics there?
Okay, so generally you need about 5 years of membership. Minimum balance isn't explicitly stated in 68B itself, but related parts mention 1,000 rupees. The amount you can take out is limited.
How limited?
It's the lowest of three things. Either 36 months of your basic wages plus dearness allowance, or the total contributions from both you and your employer plus interest, or simply the actual cost. And often, the money goes straight to the builder or a housing agency.
Not directly to you?
Not always, no. It depends on the specifics. Often, direct payment is preferred. And you can sometimes get further withdrawals later for alterations or improvements after a certain number of years.
What about paying back an existing home loan? Can PF help there?
Yes, paragraph 68BB covers that. If you have a loan from recognized places like government bodies, co-ops, nationalized banks, you might be able to withdraw funds to repay it. But the membership requirement is longer here, usually 10 years.
And there were some other housing-related paragraphs too, 68BC and 68BD.
Right. Those deal with specific housing schemes, often government-promoted ones. They can have slightly different rules and again, often involve direct payments to the housing agency or cooperative involved.
And calculating that membership period, 5 years, 10 years, it counts service across different places if it's the same employer, right?
Yes. Paragraph 68E clarifies that. For housing, and also for advances for marriage or education, your previous service counts, even if the establishment was exempt back then, provided you didn't withdraw your funds fully in between.
Okay, housing is huge, but life throws other things at you. What other urgent needs does the scheme allow advances for?
It does try to cover emergencies. Paragraph 68H is for factory lockouts or closures, or if you just haven't been paid your wages for 2 months or more.
That sounds critical. What else? Illness?
Yes. 68J deals with serious illness, major surgery, hospitalization for a month or more, specific diseases like TB or leprosy. It's for the member or their family.
Marriage. Education. Those are big expenses.
Covered in 68K. You can take an advance for your own marriage, or your children's, or even a dependent siblings, also for post-matriculation education for your kids. But there's a limit. You can only do this 3 times in total.
Only 3 times for marriage or education.
Okay.
Natural disasters.
Paragraph 68 allows a small advance up to 5,000 rupees or 50% of your own share, whichever is less, if you're affected by a major natural calamity.
And help for physically handicapped members.
Yes, 68N allows withdrawal to purchase equipment to help mitigate their handicap. These clauses really show the scheme trying to be a safety net.
It definitely seems to cover a lot of bases for difficult times. What about getting closer to retirement? Can you access funds then?
You can. Paragraph 68N lets you withdraw up to 90% of your balance once you're within 1 year of retirement, provided you're over 54.
90% is quite a lot.
It is. And there's another one, 68NNN, where at age 55 you can withdraw up to 90% to invest in a specific government pension plan, the Varishta Pension Bima Yojana.
And how do you actually get paid these amounts?
Paragraph 68 mentions the methods: post office, money order, direct deposit to your bank account, or sometimes through your employer.
Okay, so that's accessing funds during your working life or near the end. What about the final payout, full retirement?
Paragraph 69 is the main one for full and final settlement. That covers retirement based on age, permanent total disability making you unfit for work.
Migration, leaving India for good.
Yes, migration for permanent settlement abroad. Also termination due to retrenchment, like downsizing, or if you take a voluntary retirement scheme, VRS.
And sadly, if a member passes away, how are the funds handled then?
Paragraph 70 deals with that difficult situation.
Yeah.
If there's a valid nomination, the money goes to the nominee.
And if no nomination?
Then it goes to family members in equal shares. The definition of family is specific, sometimes excluding adult sons or married daughters if other family members exist.
There was also a point about someone accused of murder. 70A.
Yes, a very specific clause. If a potential beneficiary is charged with murdering the member, their claim can be put on hold pending the outcome of the criminal case. It's quite sensitive.
Understandably. And the commissioner has to make sure payments happen promptly.
Absolutely. Paragraph 72 emphasizes the duty for prompt payment and also outlines how disputes over the amount payable are handled.
Finally, just briefly, there was a section on sign workers. How does the scheme adapt for them? Their work can be quite different.
Right. Paragraph 81 and nearby sections make adjustments. Things like defining industry as film production and employee as sign worker. There's a tailored definition for excluded employee for them too.
And something about continuous membership.
Yes, a modified rule acknowledging they might work for different producers on different projects, but still maintain continuous membership. It reflects the project-based nature of that industry.
Okay, wow. That was definitely a deep dive into the Employees Provident Fund Scheme, 1952, using the documents you shared. It's clearly a really fundamental system for worker financial security in India.
It is. We've covered, who it applies to, how it's run, the contributions, and all those different ways members can access funds for housing, emergencies, retirement, and sadly, in case of death, it should give a really solid grounding.
So for you listening, the main takeaway is hopefully a clear understanding of the essentials, a shortcut through the complexity. Now here's something to think about. We saw how this scheme started in '52 and adapted over decades, bringing in IT, local government, considering today's workforce, gig economy, all the changes, what future adjustments might be needed for the EPF to keep supporting people's financial well-being effectively. Definitely food for thought. Thanks for joining us on the Deep Dive. Welcome to the Deep Dive. Today, we're really getting into the weeds on a scheme that's, well, pretty fundamental for a lot of people's retirement in India.
That's right. We're talking about the Employees Pension Scheme, 1995. You'll often hear it called EPS 95.
Exactly. And our aim here, really, is to give you a clear, understandable breakdown. Think of this as your go-to guide for the essentials. We want this to be thorough enough that you feel you've got the core information, almost like reading the key documents yourself, but much easier to digest.
Definitely. We've waded through the official scheme documents, the FAQs, even some study materials and summaries. The goal is simple. Pull out what you need to know, explain how it works, who it's for, and what the benefits really are.
Okay, let's dive in then. So the Employees Pension Scheme 1995, It didn't just appear out of nowhere, right? It was set up by the central government.
Correct. It falls under a bigger piece of legislation, the Employees Provident Funds and Miscellaneous Provisions Act, 1952. That act covers a range of benefits.
And the EPS 95 specifically, the documents say it officially kicked off on November 16th, 1995.
Yes, that's the official start date. But there's a slightly interesting wrinkle there. Eligible employees actually had an option to join retroactively from April 1st, 1993.
Ah, okay. So nearly 2 years earlier. Why was that?
Well, it was particularly relevant for people who are part of an older scheme, the Employees Family Pension Scheme from 1971. This gave them a pathway, sort of, to transition smoothly into the new EPS 95.
Got it. And who does this scheme actually apply to? Is it everyone?
Not quite everyone, but it's broad. The scheme documents state it applies to employees in factories and other establishments that are covered by that May 1952 Act. There are some specific exclusions mentioned under Section 16, but generally it covers a large chunk of the organized workforce.
So it's fair to say this is a really significant part of the Social Security setup for many, many employees in India.
Absolutely. It's a cornerstone, really. Understanding it is, well, it's crucial for employees planning their retirement and also for employers to know their obligations.
Right. Which brings us to some of the nuts and bolts. The scheme documents have these definitions. Maybe not thrilling, but you kind of need to understand them, don't you?
You really do. They unlock how everything else works. Take actual service, for instance.
Okay, what's that?
It's basically the total time you've worked, starting from November 16th, 1995, or whenever you joined if it was later, right up until the day you leave that job. Simple enough.
And that's different from contributory service.
Slightly, yes. Contributory service is the period of that actual service where pension contributions were actually paid or were supposed to be paid.
Okay, so if you took, say, a long unpaid leave, that time wouldn't count as contributory service.
Exactly. No contributions, no contributory service for that specific period.
Makes sense. And pension itself, what does the scheme mean by that?
It's actually quite encompassing. It means the payments under this 95 scheme, but it also includes any family pension benefits someone might have been getting from the old 1971 scheme right before this one launched. It shows that continuity.
Okay. What about pay? Is it just your basic salary?
No, it's broader than that. It includes your basic wages, crucially, dearness allowance, the bit that adjusts for cost of living, any retaining allowance, and even the cash value of things like food concessions if they're part of your package.
So quite a few components potentially feeding into that pay definition.
Yes, it ensures a more comprehensive base for calculating contributions and benefits later on, which leads nicely to pensionable service.
Which sounds similar to contributory service.
It is very similar. It's the period of service for which contributions have been received or are receivable into the pension fund. Basically, the service that counts towards your pension calculation.
Okay. And family. Any surprises there?
Not really. It's fairly standard. Spouse, sons, daughters. Importantly, it explicitly includes legally adopted children as well.
Good to know. And finally, who counts as a member? When do you stop being one?
You're a member if you're eligible and contributing. Membership ceases, according to the rules, when you hit 58 years old, or when your benefits under the scheme become vested, meaning secured, whichever happens first.
Right, vesting. So that's when you've met the conditions to guarantee your right to the pension.
Precisely. It defined your active participation window.
Okay, that covers the key terms.
Well.
Now the big question, where does the money for this pension actually come from? It's not just deducted from the employee's salary, is it?
No, not directly from the employee's main salary contribution to the Provident Fund. The employer plays the primary role here. They contribute to the overall Provident Fund, and from their share, 8.33% of the employee's pay is diverted into this employee's pension fund.
8.33%. Okay. Is there a limit on the pay that's used for this calculation?
Yes, there is. And this is a really important point for listeners to grasp. That 8.33% is calculated on pay up to a maximum of $15,000 per month.
So hold on. Even if someone earns, say, $50,000 a month, the employer's pension contribution is only based on $15,000 of that.
That's correct. For the mandatory contribution, the ceiling is $15,000, and the employer has to remit this amount within 15 days of the close of the month.
Wow. Okay. That ceiling is definitely something people, especially higher earners, need to be aware of when planning.
Absolutely. It directly impacts the potential pension amount, but the employer isn't the only contributor. The central government also puts money in.
Oh, really? How much?
They contribute 1.16% of the pay. Again, subject to that same $15,000 monthly ceiling.
So it's a joint effort. Employer at 8.33%, government at 1.16%, both capped at $15,000 pay.
Exactly. And remember that family pension scheme from 1971 we mentioned?
Yes.
The net assets, the money that was in that fund, were transferred over to help establish this EPS 95 fund. So it had a starting pool of money.
Oh, it wasn't built entirely from scratch. Good point. Now, who's ultimately responsible for making sure these contributions are paid? What if you work through a contractor?
The scheme is quite clear on this. The principal employer, the main company, is responsible for ensuring contributions are made, even for employees hired through contractors.
That's a significant protection for contract workers, then.
It absolutely is. It prevents companies from avoiding pension obligations just by using contractors.
And what if the employer, principal or otherwise, just doesn't pay on time? Are there teeth in the scheme? Penalties?
Oh, yes. There are provisions for levying damages for delayed payments. It's tiered based on the length of the delay.
How does that work?
Well, for delays of less than 2 months, the penalty is 5% per annum on the amount due. If it's 2 to 4 months, it jumps to 10%. 4 to 6 months, it's 15%. And for delays over 6 months, it's a hefty 25% per year.
Okay, so there are pretty strong financial incentives for employers to pay up promptly. That's reassuring for the security of the fund.
Definitely. It aims to ensure the funds are there when needed.
So let's clarify who gets to be a member, who is eligible for all this.
Okay, so generally, if you join the main employees' provident fund, EPF scheme, on or after November 16, 1995, and your pay at the time of joining is $15,000 or less, you automatically become a member of the EPS 95.
Right, automatic enrollment below that pay threshold.
Yes. And it also includes anyone who was already a member of that old 1971 family pension scheme just before this one started. They were rolled over.
Were there options for others to join? Maybe people who were in the EPF but not the old family scheme?
Yes, there were provisions, specific windows and conditions for certain existing EPF members who weren't part of the 71 scheme to opt in to EPS 95 around the time it launched. Also for some who might have left the old scheme shortly before.
Okay. And once you're in, you stay a member until
you reach age 58, or you withdraw your accumulated benefits under certain conditions, or unfortunately if the member passes away, or as we mentioned, when the pension vests. Whichever happens first marks the end of active membership.
Got it. Now, moving on to how the actual pension is worked out. Service length is obviously key. How do they calculate that eligible service period?
Right. For people who joined the workforce after EPS 95 started, let's call them new entrants, their eligible service is essentially their contributory service. The period contributions were made.
Okay.
This total period is then rounded to the nearest year. Here's how the rounding works. 6 months or more counts as a full year. Less than 6 months gets ignored.
Standard rounding, basically. Anything special for, say, seasonal workers? Their contribution periods might be patchy.
Good question. Yes, there's a specific rule for them. Even if a seasonal employee's contributory service in a particular year is less than a full year, it's still deemed to be 1 full year when calculating their total eligible service.
Ah, that's quite beneficial for seasonal employees then. What about people who are already around, members of the old scheme? How is their past work factored in?
For those existing members, their eligible service is a combination. It's their contributory service under EPS 95 plus their past service.
And past service is?
That's the service they clocked up under the old 1971 family pension scheme right up to November 15th, 1995, the day before EPS 95 started.
Okay, so it links the two schemes. Are there similar rounding rules?
Yes, the same logic applies when adding the past service and the new contributory service together. Aggregate the two, then round the total. 6 months or more becomes a full year. Less than 6 months is disregarded.
Is there any catch regarding that past service?
Well, there's a condition. If for some reason contributions for that past service under the 1971 scheme hadn't actually been paid, that period only counts towards the EPS 95 pension if those missing contributions are eventually paid into the new pension fund.
Right, so the contributions have to be there eventually for the service to count fully. Okay, that's the service duration sorted. What about the other part of the equation? Salary. How is pensionable salary determined?
Pensionable salary is the average monthly pay drawn in the 60 months. So the last 5 years immediately before you exit the pension fund membership.
The last 5 years average pay. And pay includes all those components we defined earlier, basic, DA, etc.
Correct. But, crucially, remember those contribution ceilings we discussed. They come back into play here for the calculation of pensionable salary.
Ah, okay. How so?
For the period of pensionable service rendered up until August 31st, 2014, the maximum pay considered for calculating that average was $16,500 per month.
Only $6,500.
For that period, yes. Then, for pensionable service from September 1st, 2014 onwards, the maximum pay considered is $15,000 per month.
So if you've worked both before and after September 2014, your pensionable salary calculation is sort of blended based on those two different caps for the relevant periods?
Precisely. The calculation has to factor in which cap applied during which part of that final 60-month period. It's prorated based on service under each cap.
Okay, that's complex but important. Was there any way for people earning more than these caps to get a pension based on their actual higher salary?
Yes. There was a specific option introduced around September 1st, 2014. For members who were already contributing on salaries above the previous $6,500 ceiling,
Yeah.
they, along with their employer, could jointly opt to continue contributing based on their actual salary, even if it was above the new $15,000 foam limit.
And if they chose that option?
If they opted in and made an additional contribution, 1.16% on the salary exceeding $15,005 numbers, then their actual higher average salary over the last 60 months could be used for calculating their pensionable salary, rather than being restricted by the $15,000 cap.
Right, so a way to get a pension more reflective of higher earnings, but it required an active choice and an extra contribution.
Exactly. It wasn't automatic.
Okay, so we have pensionable service, pensionable salary. Now, how does that translate into the actual pension amount you receive each month? What types of pensions are there?
The main one is the superannuation pension. This is what you get if you retire at age 58 and you've completed at least 10 years of eligible service.
10 years minimum service at age 58. What if you want to retire a bit earlier?
There is an option for early pension. You can take this if you're between 50 and 58 years old, provided you still meet that minimum 10 years of eligible service requirement.
Okay, so flexibility between 50 and 58 if you have the service.
Yeah.
Is there a standard formula to calculate the monthly amount?
Yes, for new entrants, the basic formula is pensionable salary multiplied by pensionable service, and then divide the whole thing by 70.
Salary X service, 70. Seems simple enough.
Well, simple in structure, but remember the complexity in calculating those two inputs, the prorated salary caps for pensionable salary and the rounding rules for service.
True. And is there any bonus for long service?
Yes, there is. If you retire at 58, superannuation, and you have 20 years or more of pensionable service, you get an additional weightage of 2 years added to your pensionable service calculation.
Oh, that's a nice little boost for long-serving employees.
It is. Now, for those who were existing members when the scheme started, the calculation is, frankly, more complex. It depends heavily on when their pension starts and involves factoring in their past service under the old scheme, often using specific formulae and minimums set out for different periods.
Right, so it's not one single formula for everyone across the board. What about that early pension option between 50 and 58? Is there a cost to taking it early?
Yes, there's a reduction. The pension amount is reduced by 4% for each year you are below age 58 when you start taking it.
4% per year. So if you retire at, say, 50, that's 8 years early, a 32% reduction.
That's right. It's quite a significant reduction, something people really need to factor into their decision if considering early retirement under this scheme.
Definitely. Now, is there a minimum pension amount guaranteed?
Yes. Since September 1st, 2014, there's been a statutory minimum monthly member's pension fixed at $1,000.
$1,000 minimum. Is that always guaranteed?
It's the baseline minimum, yes. However, it can be lower than Euro 1,000 if, for instance, someone had previously taken a return of capital lump sum under earlier scheme rules, or if the pension is reduced due to taking it early, as we just discussed. Those reductions can apply even to the minimum.
Okay, so the U1000 is the starting point before potential reductions. Can you choose to delay taking your pension, maybe work longer?
You can. You have the option to defer taking your pension beyond age 58 up to age 60.
And is there an advantage to doing that?
Yes. Your pension amount increases by 4% for each year you defer it after 58. So deferring for 2 years until age 60 would mean an 8% increase in your calculated pension.
Interesting. So reduction for taking it early, increase for taking it late, up to 60.
Correct. And if you actually continue working in covered employment between 58 and 60, you can also continue making contributions, which could potentially increase your pensionable service and salary calculations further.
Provides a bit of flexibility there at the end. So the scheme covers retirement. What other situations does it provide benefits for? What if you leave before reaching retirement age or completing 10 years?
Right. If you leave employment Before completing the minimum 10 years of eligible service, you're not eligible for a monthly pension. Instead, you get a withdrawal benefit.
What does that involve?
The amount is calculated based on a specific table in the scheme rules, Table D, which depends on your years of service and salary. Alternatively, you can opt to receive a scheme certificate.
A scheme certificate? What's the use of that?
It essentially freezes your accumulated pensionable service and salary details. If you later rejoin another job covered by the EPF EPS scheme, you can use that certificate to add your previous service to your new service period, potentially helping you reach that 10-year threshold for pension later on.
Ah, so it preserves your service history. Useful if you change jobs. What about disability?
Yes, there's a disablement pension. If a member becomes permanently and totally disabled while still in service, they're entitled to a monthly pension, regardless of whether they've completed 10 years.
Even without 10 years. Is there any minimum contribution needed?
Just 1 month's contribution needs to have been paid into the pension fund. The minimum disablement pension payable is 250 Brenta per month, though the actual amount depends on the member's details.
Okay. And then, perhaps the most critical safety net. What happens if a member passes away? What about their family?
This is a major part of the scheme, the family pension benefits. They provide crucial support.
How does it work? For the spouse?
The widow or widower is entitled to a monthly pension. The calculation depends on whether the member died while in service or after starting their pension, but there's a minimum widow-widower pension currently set at $1,000 per month.
$1,000 minimum for the spouse. What about children?
Yes, there's children pension. Each child receives 25% of the amount the widower gets, subject to a minimum of $250 per month per child. This is payable for a maximum of 2 children at a time, until each child reaches 25 years of age.
25% of the widow's pension, minimum euro of 50, up to 2 kids until age 25. What if, tragically, both parents pass away?
In that case, it becomes orphan pension. Each orphan receives 75% of the widow-widower pension amount, subject to a minimum of $750 per month per orphan. Again, it's for a maximum of 2 orphans, payable until age 25.
Okay, 75%, minimum $750 for orphans. Are there provisions for children with disabilities?
Yes, importantly, if a child or orphan is suffering from permanent disability preventing them from earning a living, the children and orphan pension can continue even after age 25 for their lifetime.
That's a vital provision. What if a member dies without a spouse or eligible children?
Then the benefit can go to a nominee that the member designated. If there's no nomination, then dependent parents could be eligible for a pension, typically equal to what the widow-widower would have received.
So there's a clear order of precedence for beneficiaries.
Yes, and a really key guarantee for members and their families. The scheme documents assure that these pensionary benefits are guaranteed, even if the employer defaults on paying their contributions.
That's huge. So the family won't suffer because of an employer's failure.
Exactly. The liability to pay the missing contributions remains with the employer, but the pension payment itself is secured by the fund.
That offers significant peace of mind. Okay, we've covered benefits. How is this whole massive scheme actually managed? Who runs the show?
Operationally, the Employees Provident Fund Organization, EPFO, manages it. The Regional Provident Fund Commissioner is usually the point person for resolving doubts about membership or eligibility.
Is the process for claiming benefits straightforward?
The aim is efficiency. The scheme mandates that complete claims should be settled within 20 days. There are even penalties mentioned for delays caused by the authorities without proper justification.
20 days is pretty quick. What are the duties of employers in this?
They have several. Submitting regular returns, paying contributions on time, providing necessary information to the EPFO. Even contractors have a duty to furnish details about the employees they supply to the principal employer.
So information flow is key. Do people get new account numbers for this pension scheme?
Generally, no. Your existing Provident Fund account number is usually retained and used for the pension scheme as well.
Okay. And the money in the fund, how is it invested? Where does it go?
The employer and employee contributions, part of the overall PF contribution, are invested according to the guidelines set out in the main EPS scheme, 1952. The central government's contribution, however, is kept in the government's public account.
Different streams of investment and the fund itself. Can it be used for anything else?
The pension fund is quite restricted. It can generally only be used for paying out the specified pension benefits and for the withdrawal benefits we discussed. The administrative expenses of running the EPS 95 are actually met from a separate interest account within the main EPF scheme, not directly from the pension fund capital.
Interesting separation. Is the fund audited?
Yes, annually. There's an audit and also an actuarial valuation of the fund each year to assess its long-term financial health.
And who actually handles sending out the monthly pension payments?
The EPFO uses various dispersing agencies, typically banks, to handle the actual crediting of pensions to the pensioners' accounts.
Makes sense. Any other administrative points?
Well, there are regional committees that have an advisory role. The performance and status of the EPS 95 are included in the EPF organization's overall annual report. And if the EPS 95 rules are silent or insufficient on a particular procedural matter, the provisions of the main EPF scheme, 1952, generally apply.
So the EPF scheme provides the fallback framework. You mentioned earlier that some companies might run their own pension schemes. Can they get out of EPS 95?
Yes, there's a provision for exemption. An establishment can apply to the government for exemption from EPS 95 if they have their own pension scheme that offers benefits that are, on the whole, not less favorable, so comparable or better than the EPS 95 benefits.
How does that work?
There's a formal application process involving the EPFO, assessment of their scheme rules, trust funds, etc. Even if granted exemption, these establishments still need to file monthly returns in Form 1 with the Regional Provident Fund Commissioner.
Right, so they still have reporting obligations. Okay, let's try and pull this all together then.
Sure.
So, the Employees Pension Scheme, 1995, EPS 95, it's a defined benefit scheme, part of India's social security system, managed by the EPFO.
Correct. Funded mainly by a diversion from the employer's PF contribution, 8.33% on up to 15K pay, plus a government contribution, 1.16% on up to 15K pay.
Membership is generally automatic for EPF members earning $15,000 or less when joining, and for those rolled over from the older 71 scheme.
Right. Key benefits include monthly pension upon retirement at 58, superannuation, or earlier, between 50-58 with reduction, provided you have at least 10 years of eligible service.
And that pension calculation uses the formula, pensionable salary x pensionable service, 70, remembering the complexities around calculating those two elements, especially the salary caps of 6,500 and 15,000K.
Exactly. Plus, there's the 2-year service weightage for 20-plus years service at superannuation, and minimum pensions apply, like $1,000 for members, widows, and specific amounts for children orphans.
And crucially, it offers withdrawal benefits for shorter service, disablement pension, and extensive family pension provisions for spouses, children, orphans, and even nominees or parents.
And that guarantee of benefits, even if the employer defaults, is a really core protection.
Absolutely. We've covered its origins, funding, eligibility, how pensions are calculated, the range of benefits, and the basic administration. It's quite a comprehensive system.
It really is. Hopefully this deep dive has unpacked it in a way that's clear and helps you, the listener, understand how it works and how it might apply to your own situation or people you know.
Yes, we aimed for that clarity and thoroughness. Of course, for very specific personal situations, checking the official EPFO resources or the full scheme documents is always advisable.
Definitely. Which perhaps leads to a final thought to leave people with.
Go on.
As work patterns change, lifespans increase, and the economy evolves, how do schemes like EPS 95, which were designed decades ago, need to adapt to ensure they remain relevant and sustainable for providing real financial security in retirement for the generations to come?
That's a really pertinent question. The balance between sustainability and adequacy in a changing world, something definitely worth pondering. Securing our future after our working years is something we all think about, and a key part of that for many in India is the Employees Pension Scheme, or EPS 1995. It's a really fundamental pillar of Social Security.
It truly is. Yeah, this scheme has a A broad reach, offering a crucial layer of financial stability for retirees and, vital support for their families when needed.
And to really get under the hood of how this all works, we've got the Manual of Accounting Procedure, EPS 1995. Think of this as the definitive guide.
Very much, yeah.
Our goal today is to break down this manual for you, our listener, and pull out the essential information about how the EPS functions, who is eligible, and the various benefits available, all in a hopefully clear and straightforward way. Ready to dive in?
Absolutely. And, it's important to remember that this manual gives us a very detailed look, the real nuts and bolts of the EPS. It's more than just knowing a pension exists. It's about understanding the specific rules, the steps involved, making it accessible, really.
Okay, let's unpack this then. First question. Who can actually become a member of this scheme? It revolves around membership and eligibility, right? The manual lays out several scenarios, some dating back quite a way.
It does, and it's interesting how it evolved. For example, if you were already part of the Employees Provident Fund Scheme, that's the main retirement savings scheme, before November 16th, 1995,
Okay.
and you weren't in the old family pension scheme, you had the option to join the new EPS retroactively, as long as you were under 60 then.
So bringing existing PF members into the fold.
Exactly. It was about consolidating things, bringing them into this updated pension framework.
That sounds like a sensible move. What about people who might have left the old family pension scheme around that transition period?
Good point. The manual specifies that.
Yeah.
If you left the Employees Family Pension Scheme between, April 1st, 1993 and November 15th, 1995.
Right.
Maybe you turned 60 or your job ended. You still had the opportunity to opt into the EPS from the date you left.
Even if you'd already hit 60.
Yeah, even if you hit 60 during that period but kept working, you could still join from your 60th birthday.
Yeah.
It shows an effort, to ensure people weren't left out by the changeover.
So it seems like they were trying to make it as inclusive as possible during that transition. There's also a mention of individuals who weren't employed back in 93 but still had some kind of PF membership.
Yes, that's a more specific case. If you weren't employed on April 1st, 1993, but you'd kept your membership in the old family pension scheme and still had your Provident Fund membership,
Okay.
you were eligible to join the EPS, provided, again, you were under 60 on March 31st, 1993.
Interesting nuances there. Now, what if someone had completely cashed out their Provident Fund before all of this kicked in?
Generally, if you made a final withdrawal of your Provident Fund before November 16th, 1995, you wouldn't be eligible. Simple as that.
Right.
However, and this is a key point, if you only took a partial withdrawal, and importantly, kept your PF membership active, then you could still opt in. But you'd need to settle any outstanding dues first. So keeping that link to the PF was usually essential.
Okay, so retaining that membership seems crucial. What about after the scheme became compulsory then? After 95?
Right, after November 16th, 1995, things got simpler in a way. If you join an establishment that's covered under the EPS, you automatically become a member.
Just like that?
Pretty much. Even if you had, say, kept EPS membership from a previous job without actually withdrawing benefits, you join automatically at the new place. You don't need to actively sign up again. It's mandatory if the workplace is covered.
That definitely simplifies things for employees starting after that date. How long does this EPS membership actually last? Is it lifelong?
Well, your EPS membership continues until one of four things happens. One, you reach 58 years old. Two, you withdraw your benefits.
Which usually happens if you have less than 10 years of service.
Exactly. Before age 58, if you don't hit that 10-year mark. 3, you pass away. Or 4, your regular monthly pension payments actually begin.
And what happens if you switch jobs? Move between companies? Do you lose your membership and have to start all over again?
Not at all, thankfully. The scheme has portability built in through something called a scheme certificate.
A scheme certificate?
Yeah, think of it like a record of your pensionable service that you carry with you. When you move from one covered employer to another, you use this certificate to transfer your previous membership period.
So your service adds up over time.
Precisely. It's really important for building up enough years to actually qualify for a pension. Of course, if you've already fully withdrawn your benefits, then membership ends and you can't transfer anything.
That scheme certificate sounds like a really vital tool, especially for people who changed jobs during their careers. The manual also briefly mentions eligibility in cases of belated coverage. What does that mean?
Yes. belated coverage. This basically refers to situations where an employer should have been contributing to the EPS for their employees from an earlier date, but for whatever reason, the scheme's coverage only got applied later on.
So the company was late joining.
Essentially, yes. In these cases, the employees become eligible for EPS membership from the day the coverage actually starts. But crucially, their past service with that employer, as long as it's documented, is still taken into account when their pension benefits are eventually calculated.
All right, so that clarifies who can be a member and how membership works. Now, let's get to what everyone really wants to know. The actual benefits you can receive under the EPS in 1995. Seems like there's quite a variety.
Yes, there's a whole spectrum of benefits, really, designed to provide financial aid in different life stages and circumstances. First off, there's the withdrawal benefit.
Okay, what's that?
This is basically a lump sum payment. You can get this if you haven't completed at least 10 years of service before you turn 58. It's more like a return of contributions when you don't qualify for the actual pension.
Right, not enough service for a monthly pension, so you get a payout. Makes sense.
Exactly.
And we've already talked about the scheme certificate helping transfer membership, but it seems it also plays a role in some really difficult situations.
That's right, it does. It's quite an important safety net. If someone holds a scheme certificate and unfortunately passes away before reaching 58, and they have less than 10 years of eligible service, and there wasn't a continuous 36-month gap with no contributions, then their past contributions can actually be converted into a monthly pension for their widow or children.
Really? Even with less than 10 years?
Yes. The amount for the widow or widower is based on rates in a specific table, Table C in the manual, and each eligible child up to 2 would get 25% of that widow's pension amount.
And if there's no spouse?
Then an orphan pension becomes payable. That's typically 75% of what the widow's pension would have been, subject to certain conditions. It's a really vital provision for families in those, tragic circumstances.
That truly is. Then there's the monthly member pension, which I guess is the main retirement benefit we all think of. The manual just says details are available.
Exactly. That's the core pension you get after retirement, assuming you meet the service criteria. We'll likely touch on how it's calculated later.
Okay. And then there's an option for early pension.
Yes. You can choose to start receiving your pension before the standard retirement age of 58. But there's a catch, a trade-off.
Always a catch.
So, yeah, for each year you are younger than 58 when you start, your pension amount is reduced by 4%.
So a significant reduction if you take it quite early.
It can be, yes. And to be eligible for this early pension, you need to be at least 50 years old and have completed a minimum of 10 years of service.
50 and 10 years minimum, got it.
Interestingly, though, there's also an added benefit for those who work right up to 58 and have a long service record. If you have 20 or more years of service, and this applies for service after July 23rd, 2009,
Yes.
you actually get an extra 2 years of service added to your calculation, like a bonus. So there's a bit of an incentive for longer service right up to 58.
So a little encouragement to work towards the standard retirement age if you've been in the system for a good while. The manual also mentions a disabled member pension.
Yes. This benefit is available for members who become completely and permanently disabled during their employment, making them unable to work.
The specific criteria and calculation details would be laid out further in the manual.
Okay, now let's consider what happens to a member's family if the member passes away. There's a widower pension.
This is a crucial benefit, yeah. Payable to the surviving spouse after the member's death. There is a specific condition mentioned, though.
Oh.
If a judicial separation was granted because of proven adultery, and the member dies during that separation, the spouse found guilty of adultery wouldn't be eligible for this pension.
That's quite specific.
It is. But importantly, in that situation, any eligible children would still be entitled to receive an orphan pension. Their benefit isn't affected by that ruling against the spouse.
That's an important distinction. And what about the children pension more generally? Who qualifies?
Eligible children include, biological children, legally adopted children, and even children conceived posthumously but born before the member's retirement date.
But children adopted after the member's death or after their pension has already started are not eligible.
And how does it work if there are multiple children?
The entitlement is based on their birth order, regardless of, say, different marriages. At any one time, a maximum of 2 children can receive this pension. If there are more eligible kids, they effectively share the pension slots based on the birth order of the younger ones, as the older ones age out or become ineligible.
And when does the children pension stop?
It stops when the child reaches 25 years of age, or if they pass away before that, whichever comes first.
Right.
Also, if the widow or widower receiving pension dies or remarries, the children's pension then converts into what's called an orphan pension, which has slightly different rules.
Okay.
And importantly, since September 1st, 2014, there's been a minimum pension guarantee of €250 per month for each eligible child.
That's good to know.
And even more significant, there's a provision for children with disabilities. They are entitled to receive pension for their entire lifetime. No age limit, and they aren't subject to that two-child restriction either.
Wow, lifelong support for disabled children. That's really significant.
It really is. The manual apparently includes a table showing how pension is split in families with both non-disabled and disabled children. It's a very commendable aspect of the scheme.
Definitely. Now, what happens if a member passes away and doesn't have what the EPS defines as family? No spouse, no eligible kids, but they did nominate someone.
Ah, yes, the nominee. In that specific case, the person nominated is eligible to receive a monthly nominee pension.
Okay.
But there's a condition here too. If a member without a qualifying family starts drawing their own monthly pension and then passes away, their nominee is not entitled to receive any further pension after the member's death.
So the nomination only really counts if the member dies before starting their own pension.
Broadly speaking, for the nominee to get a pension, yes. There's also a minimum nominee pension amount, which is both $1,000 per month since September 1st, 2014.
Okay, and what if there's no family and no nominee designated? Is there anyone else?
Then, the dependent parent pension might come into play. If the member was unmarried or doesn't have a living spouse, eligible child, or a nominee, their dependent parents can receive a pension.
How much do they get?
It's equivalent to the widow's pension amount. It's paid first to the father, and then upon his death, it passes to the mother, provided they remain dependent.
And the same rule applies if the member was already drawing pension.
Yes, similar to the nominee situation. If a member without family starts receiving their monthly pension and then dies, the dependent parents are not entitled to a pension afterwards. However, if the member died without enough service to qualify for a monthly pension themselves, the dependent parents might still be eligible for the withdrawal benefit instead.
So the scheme really tries to cover a lot of different personal situations. Let's loop back to the orphan pension, which you mentioned comes up when children lose both parents or the remaining parent remarries.
Exactly. The orphan pension starts after the death of a member who didn't leave a spouse, or after the death or remarriage of the member's widow or widower.
And the rules are similar to the children's pension.
Mostly, yes. It continues until the orphan turns 25 or passes away, whichever is first. It's generally limited to a maximum of 2 orphans at a time. If there were multiple widows, the orphan pension only kicks in after all eligible widows have passed away.
Okay.
One difference is that orphans who are at least 18 years old can actually claim the pension directly themselves. And again, that crucial exception for disabled orphans applies. They receive a lifelong pension, and there's no limit on the number of disabled orphans from the same member who can receive this benefit.
It's good they kept that lifelong support consistent. The manual also addresses a really tough situation: missing persons.
It is, yeah. A very difficult circumstance.
Yeah.
The manual outlines that if an employee disappears, leaving their family in limbo, the family can be granted a family pension after a waiting period of 1 year.
1 year. What needs to happen during that year?
Certain conditions have to be met. The family must file a formal police complaint and then get a report stating the missing employee couldn't be traced despite efforts.
Okay, a police report is key.
Yes, and they also need to provide a legal undertaking, basically promising that if the employee reappears and makes a claim later, any pension paid to the family will be adjusted.
Makes sense.
So 1 year after the date the first information report, FIR, was lodged with the police, the family can then apply for the pension. The amount is based on the last salary drawn by the missing employee.
And this applies across the board for family benefits.
Yes, the manual says these same rules for missing persons can also be applied to claims for widow, children, including disabled, orphan, and even nominee pensions under the EPS. It provides a way to offer some financial support during those incredibly uncertain times.
A vital lifeline in a terrible situation. Finally, under benefits, there's a mention of debarring a beneficiary. That sounds quite serious.
It is. It concerns situations where someone who is said to be a beneficiary, usually a child, is formally charged with the murder of the member, or with actively helping in that crime.
Right.
In that case, their share of the children's pension can be temporarily suspended. Just put on hold until the criminal proceedings are officially finished.
What happens to the pension during the suspension?
Any other eligible children will continue to receive their shares as normal. If the accused beneficiary is eventually acquitted, found not guilty, then their suspended pension payments, including all the back payments, arrears, will be released to them. However, if they are convicted, found guilty,
Then what?
then their share of the children's pension is permanently forfeited and will be distributed amongst the other eligible children, if any, until they too become ineligible. It's a necessary safeguard, really, to prevent potential misuse of the scheme funds.
That makes perfect sense. Okay, let's shift our focus now. We've talked about who gets in and what benefits they might receive, but underpinning all of that are some fundamental elements: age, service, and salary. These seem to determine everything.
They absolutely are the cornerstones of the EPS, yeah. Let's start with age. The manual is clear. Age is critical. It determines your initial eligibility, when you can actually start receiving pension, and even the amount you get. It all hinges on your date of birth.
And how is that date of birth established, especially if records are missing or unclear?
Right. For new members, or where there are discrepancies, the manual specifies a list of acceptable documents for proof of age. This list is actually detailed in an Appendix Annexure I of a specific standard operating procedure for joint declarations about date of birth.
So a standardized process for verification. Good.
Yes, it ensures consistency and reliability for this crucial piece of information.
Are there any particular age-related rules or checks we should be aware of?
Yeah, a couple of things. Generally, if a member is under 58, it flags a check about whether they might be eligible for that higher wage pension option we'll probably discuss later. Also, for people who joined the EPS before September 1st, 2014, different rules about wage ceilings and calculations might apply. So age helps determine which set of rules is relevant for them.
But some benefits aren't age-restricted.
Correct. Importantly, the standard age restrictions don't apply for disability pensions or for widow and children's pensions. And of course, if children receiving benefits are minors, payments go to their legal guardian.
That's good to know. Now let's move on to service. The manual talks about eligible service and actual service. What's the difference there?
Okay, so eligible service is basically the time you worked in a covered job that counts towards your pension calculation. Actual service is the total time you were employed in such jobs, which might include periods that don't count towards pension, like maybe long unpaid leave where no contributions were made.
So not all time worked necessarily counts for pension.
Not always. The manual does say short breaks, like temporary layoffs or leave without pay, aren't automatically excluded from your actual service, unless contributions definitely weren't received for those periods. Interestingly, it stresses that benefits shouldn't be denied just because the exact details of such breaks aren't formally submitted. Employer info or transfer documents can be used. If nothing's available, the break period is usually just counted as 0 for calculation.
And how is past service, maybe from different jobs, treated when adding it all up?
Yep.
Is there a rounding?
Yes, there's a rounding rule. When you combine past service with current service, any period that's less than 6 months is just ignored. But if a period is 6 months or longer, it gets rounded up to a full year.
6 months or more becomes a full year.
Okay, that applies when calculating your total eligible service for pension.
And the calculation of the actual service period itself, how is that defined? From when to when?
Your actual service runs from the date you first joined a job covered by EPS, or from November 16th, 1995, if you joined after that date, right up until the date you leave that service, or your date of death, or the date you hit 58, whichever happens first.
And what about seasonal workers? People whose jobs aren't year-round.
Good question. For seasonal employment, even if you work less than a full year in a calendar year, that period is still counted as 1 full year of actual service. That's quite beneficial for those in seasonal industries.
Definitely. Now, there's also a note that any period where you received a withdrawal benefit doesn't count as pensionable service.
That's correct. If you previously took that lump sum withdrawal benefit because you had less than 10 years service, that specific period of employment doesn't count towards calculating a future monthly pension.
So you can't double dip, essentially.
Pretty much. Similarly, any non-contributory period within your actual service time employed, but no pension contributions made, is also excluded when calculating your total pensionable service.
Okay.
But remember that service weightage we mentioned earlier?
Your extra 2 years.
Yes. If you retire right at 58 and have 20 or more years of pensionable service after July 23, 2009, those 2 extra years get added on. That can give your pension a nice boost.
So that weightage really rewards long service right up to retirement. Finally, on service, how is it calculated for people who worked under both the current EPS and the older family pension scheme that existed before 95?
Simple answer there.
Yeah.
It's all combined. All the service you rendered under the old family pension scheme and the current EPS is added together when calculating your total pensionable service. Your whole history under both schemes counts.
All right, that clarifies age and service. Now for the third critical piece, salary. How is your pensionable salary actually determined under the EPS? This sounds key.
It absolutely is. Generally, your pensionable salary is calculated as the average of your wages during the 60 months. That's 5 years immediately before you exit the pension.
It's the last 60 months, okay.
However, there's a historical difference. For any service you had before September 1st, 2014, the average is based on the 12 months of wages you received just before that date.
So 12 months before 2014, 60 months after.
Essentially, yes. And crucially, these average salary calculations are always subject to the statutory wage ceilings that were in effect during those different periods. Right now, that ceiling is $15,000 per month.
So if someone's career spans that 2014 date, the calculation gets a bit more complex, like a pro rata thing.
Exactly. It's a blended calculation. For service up to September 1st, 2014, the maximum wage considered for pension was $6,500 per month. After that date, the ceiling went up to $15,000.
Right.
So if your service covers both periods, your pensionable salary is worked out on a pro rata basis, reflecting how much service fell under each ceiling.
What happens if an employee wasn't actually receiving their full pay during those last 12 or 60 months? Maybe they were on leave or something?
The manual covers that. If you weren't on full pay for that entire averaging period, the average salary is calculated based on the full pay you actually drew during the specific period for which contributions were made.
How do they work that out?
They take the total wages you received during those relevant months, divide it by the actual number of days you worked and were paid for, and then multiply that daily average by 30 to get the average monthly pay. It ensures the calculation is based on your actual earning rate during the contributing period.
Okay, that seems fair. The manual apparently gives examples too. It also briefly mentions how benefits from past service before EPS even started in 95 are calculated.
Yes, for any service before the current EPS began, the pension benefits for that period are calculated based on your pay as it was on November 16, 1995, or your exit date if you left before that.
And how did that work?
There were two different salary slabs used back then. One for salaries up to $2,500 Brent per month and another for salaries above that. The specific pension formula for that past service is detailed separately in the manual.
And what about salary variations in the very last month of work, the exit month? Can that affect things?
The manual acknowledges that wages might fluctuate in the final month. It says, if the exit month's wages are within 10% up or down of the average salary calculated over the preceding period, it's generally acceptable.
But what if it's a bigger difference, more than 10%?
Then it might need a closer look. The regional commissioner or the RPFC for finance might need to review the case and decide on the wages to be considered. They might even need to check with the employer about why there was such a big difference.
And how do they handle that final month's pay for calculation?
To get a standard 30-day equivalent for the exit month, they take the total pay drawn in that month, divided by the actual number of days the employee worked and was paid, and then multiply that daily rate by 30. It gives a consistent monthly figure for that final piece of the calculation.
So a very thorough process to ensure fairness, even with last-minute fluctuations. Now, let's move on to a topic that's seen a lot of discussion recently. Pension on higher wages.
Yes, this has been a very significant area. The manual outlines the provisions for potentially getting a pension calculated on your actual wages, which might be higher than those statutory ceilings of $6,500 or $15,000.
And this relates to that big Supreme Court judgment.
Exactly. It specifically mentions the Supreme Court judgment from November 4th, 2022, and the whole process that followed for people to validate options for contributing on higher wages.
There were specific deadlines for applying for those options, right? It wasn't just open-ended.
That's correct. Very specific deadlines. There were basically two main groups. People who retired before September 1st, 2014 had a window to apply to validate any existing joint options they might have had.
Okay.
And then people who were members both before and after September 1st, 2014, but hadn't been able to exercise a joint option earlier, also had a specific process and timeline.
And those deadlines have passed now.
Yes. The manual clearly states the last date for submitting these applications was July 11th, 2023. And it notes that after this date, no more applications could be accepted, partly due to technical limits in the online portal. So those specific opportunities are closed now.
So people had to act within those defined periods. What did the application process actually involve for those who were eligible?
It was mainly online. Through the EPFO's member portal, there were different links depending on whether you were already retired or still working.
Right.
The online forms had various disclaimers and declarations you had to read and accept. Once submitted, the application went for scrutiny by officials at the EPFO regional offices, usually APFCs or RPFCs.
And they made the decision.
They reviewed it and presented the case details to the officer in charge of the regional office. The final decision was then communicated formally through a speaking order, usually by email or post. They also tried to inform people via phone or SMS and let the last employer know too.
What kind of proof or documents did people need to provide with these applications, especially for the joint options?
This was critical. You absolutely needed proof that the employer's share of the Provident Fund contributions had been consistently paid on wages above the old statutory ceiling, $5,000 or $6,500 back then.
Okay, proof of payment on higher wages?
Yes, and also evidence of a joint option having been formally exercised under the EPF scheme rules, paragraph 26. And importantly, this evidence had to be verified by the employer.
What counted as evidence?
Things like wage details certified by the employer, copies of salary slips confirming the higher wages, and PSF copies of the actual joint request signed by both employee and employer, or even letters from the PF office from before the Supreme Court judgment that showed contributions were being made on higher pay. Employer verification was really key.
Definitely sounds like it. What if the EPFO needed to dig deeper, verify the wage details further?
The manual outlines a verification process. Field office teams, enforcement officers, accounts officers could be sent to the employer's premises to check the records directly.
Like an audit?
Sort of. Specifically focused on the applicants for higher pension. They usually give the employer about 7 days' notice. The aim was to check all applicants from one company in a single visit, if possible.
And then?
The team would write a report, submit it to the APFC or RPFC, who would then review it, make the final call on the application, and issue that speaking order explaining their decision.
What if documents were missing or there were issues found during verification? Was it an automatic rejection?
No, the manual emphasizes fairness here. Before rejecting any application, the pensioners, members, and the employers would be given a reasonable chance to submit any missing info or clarify any discrepancies found.
So an opportunity to fix things first.
Exactly. A chance to rectify issues before a final no.
That seems fair. The manual also mentions the Code on Social Security 2020. How does that tie into this higher wages issue?
Right. Some parts of that code came into effect in May 2023, but were applied retrospectively from September 1st, 2014. One key thing for higher pensions is an extra employer contribution.
Another contribution.
Yes, specifically an additional 1.16% of the salary above the $15,000 threshold. This extra 1.16% comes out of the employer's overall PF contribution share. So for wages over $15,000, the slice going to the pension fund effectively increases.
So for those approved for higher pension, there's this additional 1.16% contribution that needs to be accounted for from September 2014 onwards.
That's correct. For all the eligible joint options, this extra 1.16% on the pay above $15,000 needs to be factored in. It comes from the employer's share.
And what about past contributions if they only went to PF, not pension fund?
Adjustments are needed there too. The appropriate 8.33% or 9.49% post-2014 for the basic amount needs to be transferred from the employer's PF share to the pension fund. And for members still working whose option is approved, the employer just continues making contributions on the higher wages, including that extra 1.16% bit.
How are these extra amounts, these dues, actually calculated by EPFO, and how do employers pay them?
The EPFO field office calculates the total dues after verifying all the wage details. This includes the 8.33%, 9.49% share on higher wages for the relevant periods, plus that additional 1.16% from September 2014, minus anything already deposited into the pension fund.
And interest.
Yes, interest is charged on these dues at the same rate the members earned on their own PF accumulations during that time. Employers pay these dues using a specific challan or through the online ECR system, making sure to mention the employee's application ID, UAN or PPO number, name, etc.
What if a pensioner needs to pay directly?
They can deposit it into a designated centralized receipt account using a member VDR, and they must specifically label the payment pension on higher wages so it gets allocated correctly.
Okay, so once all these dues are sorted, how is the actual pension amount calculated in these higher wage cases? Is there a different formula?
No, the manual is quite clear on this. There's no separate formula formula for higher wage pensions, the standard EPS formula still applies.
Which uses pensionable service and pensionable salary.
Exactly. And the pensionable salary is determined the same way we discussed. Average of the last 12 months if pension started before Sept 1st, 2014, or average of the last 60 months if it started on or after that date, based on the actual higher wages, of course, but using the standard averaging method. The manual gives examples showing how this works out.
So the input salary is higher, but the method is the same. Got it. Finally, on this topic, the manual mentions FAQs.
Yes, it points out that a detailed set of frequently asked questions specifically about implementing the Supreme Court judgment on higher pensions is available on the main EPFO website.
That sounds like a very useful resource for listeners wanting more specifics.
Definitely worth checking out if this applies to you.
Okay, let's shift gears again. Let's look at practicalities. The procedure for receipt and processing of claims. How do people actually apply for their benefits?
Right, the claims process. The manual details how claims for all the different EPS benefits are received and handled. Good news is there are several ways to submit a claim.
Like what?
You can do it online through the member portal. You can send it by regular post. You can submit it directly in person at an EPFO office. Or some offices might even have a designated drop box.
So multiple options for convenience.
Exactly. Trying to make it easier for people to start the process.
What's the very first step once a claim, say a paper form or an online application, actually arrives at the EPFO?
It goes through an initial check, a scrutiny process. Online claims submitted via the portal usually go straight into the system, landing in the relevant dealing assistance workload.
And physical offline claims.
For those, the first handling step depends on whether the member have a valid UAN, that's the universal account number, and if their Aadhaar number is linked or seeded with that UAN.
So having a UAN linked with Aadhaar speeds things up.
Absolutely. It generally means less initial paperwork and potentially faster processing. If Aadhaar isn't seeded, they might advise submitting a joint declaration form to get that done.
What if someone doesn't even have a UAN?
If they're an existing member without one, EPFO staff are supposed to help allot one, partly so they can use the online facilities later. When people submit claims in person, staff check the UAN Aadhaar status first and guide them on any extra steps needed.
What's a specific process for handling those physical offline claim forms? Is there tracking?
Yes, very much so. All offline claims are logged in a formal claim inward register at the office. This acts as an official record, tracking each claim from arrival.
Like a logbook.
Exactly. The section handling incoming mail, DAC section, usually lists all claims received daily and forwards the list and the documents to the right section, like the pension section. This register is often kept in triplicate for tracking. And managers, like the PRO or APFC, can use reports in the EPFO software to monitor the status of all incoming claims.
And what are the essential documents needed for different types of pension claims? Does it vary?
It does vary a bit depending on the claim type, member's own pension, widows, children's parents, nominees, but there are common things.
That's it.
Generally, you need the correct claim form, usually Form 10D for most pensions. Proof of your bank account, like a canceled check or statement copy. For family pension claims, obviously, the member's death certificate is essential.
Right.
For children's claims, you usually need birth certificates or school leaving certificates for age proof, and maybe Aadhaar copies. For dependent parents or nominees, having the original Form 2 nomination form or a valid e-nomination record is often key to prove their right to claim.
Are there other specific documents needed sometimes?
Yes. For instance, if a member died soon after leaving service with less than 10 years total service, that might affect certain family pensions and requires specific checks. Members claiming their own pension might need to self-certify about their employment history or confirm they don't hold other scheme certificates. Getting all the right documents together up front is really crucial for smooth processing.
It really sounds like having your paperwork in order from the start is vital. What happens after the claim is received and the initial documents are checked? What are the processing steps?
Okay, the core processing involves several key stages. First, a thorough verification of the member's entire service history across all covered jobs. Second, a detailed check of the wages reported and contributed on. Third, the actual accurate calculation of the pension benefits based on EPS rules.
And that calculation involves checking service before and after 2014.
Yes, the system specifically verifies service pre-September 1st, 2014, and post that date, because of the different wage ceilings and rules. If someone had previously taken a withdrawal benefit but later returned it, there's a special module, often called the Form 10C special module, used to handle that specific scenario.
And once everything is verified and calculated,
a pension payment order, the PPO, is officially issued. There's also a provision: if a member sadly died before their own withdrawal benefit was paid out and met certain conditions like dying within 3 years of leaving with less than 10 years service, EPFO can convert that pending withdrawal claim into a family pension claim for the widow or children.
that's good, ensuring the family still gets potential benefits. What about transfers? If someone moves state after retiring, how do they get their pension paid in the new location?
Right, transfer cases. If a member wants their pension paid in a different state or territory, they're usually advised to open a bank account with a designated bank there. But the actual pension claim can still be processed by the regional office where they were last employed.
So the original office still processes it.
Yes, the originating RO prepares a comprehensive input data sheet with all the members' details, service, calculated pension, etc. This sheet is then sent securely, usually electronically, to the RO in the new region where the pensioner now lives.
And the new RO takes over payment.
Exactly. The transferee RO takes responsibility for the actual disbursement. Any scheme certificates from previous jobs are also factored in by the originating office when calculating the total entitlement before transfer.
And before that final pension payment order, PPO, is generated, are there final checks?
Yes, absolutely. Critical step. Before the pension calculation worksheet gets the final okay, both the dealing assistant who processed it and the section supervisor for pensions have to double-check everything.
What exactly do they check?
Key things like the pensioner's bank account number and name matching the bank records, all the personal details of the beneficiary matching the documents, and very importantly, ensuring the current correspondence address and contact info, phone, email, are correct in the system.
Why is the contact info so crucial?
So EPFO can actually reach the pensioner if needed later for any communication. Only after all these checks are done and the worksheet is confirmed, accurate, is it approved. Then the PPO is generated, often electronically now, and sent to the pensioner, maybe via email. Any arrears due are also released then.
Okay, that covers the processing. Let's now move on to how the money actually gets paid out each month, the disbursement of pension.
Right. Pension payments under EPS are made monthly. They go through designated banks or other authorized agencies that have specific agreements with EPFO.
How does the money flow?
EPFO calculates the total amount needed for all pensioners for the month in advance. This bulk amount is then electronically transferred to a specific link branch of each designated bank. The money sits in a special account held by the Regional Provident Fund Commissioner there.
So EPFO basically pre-funds the banks with the total pension payout for the month.
Exactly. Then at the end of the month, the bank sends back a detailed credit statement to EPFO. This statement lists every individual pension amount successfully credited to each pensioner's account.
And EPFO checks this statement.
Rigorously. They reconcile the bank statement against their own records. This ensures payments were accurate, identifies any issues like pensions not credited or wrong amounts. Any discrepancies are immediately taken up with the bank. The whole process is overseen by the RPFC to maintain integrity.
Are there specific controls to prevent errors or fraud?
Yes. The manual suggests things like rotating staff in the pension processing and bank reconciliation sections. Also, sticking strictly to communication protocols with banks, like avoiding physical exchange of sensitive financial statements. The officer in charge of the RO is also meant to regularly review the timeliness of payments, reconciliation progress, bank balances, service charges, and handle any pensioner grievances.
What about those service charges the banks levy for doing this work? Who pays for that?
Good question. The service charges banks levy for dispersing pensions are paid directly from the employee's pension fund itself. That's EPF account number 10.
So it comes out of the main pension fund.
Yes, they are classed as disbursement expenses, not general admin costs. The agreements on these charges are reviewed periodically, especially with changes in payment tech or issues like the digital life certificate process. Any applicable GST or TDS on these charges is handled by EPFO2.
When do the banks actually get paid these charges?
Only after EPFO confirms successful pension disbursement, gets details of any non-payments, status of any recoveries, and completes the monthly reconciliation for that bank through their software.
Okay. The digital life certificate, Jivan Praman, that's become really important for pensioners, right? How does the manual cover this?
Yes, it's crucial. The manual details the process for submitting the DLC, which is the main way pensioners prove they're still alive and eligible. The preferred way is usually digital Jeevan Praman website or app, often using Aadhaar biometrics.
But what if someone can't do that? Maybe no Aadhaar or biometrics fail?
The manual acknowledges these exceptions. Banks handling disbursements have instructions. For someone without Aadhaar, the bank might accept a traditional paper life certificate, but only after getting their Aadhaar enrollment slip and doing thorough ID checks using other official documents.
And if biometrics keep failing?
Banks are told to explore alternatives, like using iris scanners, or maybe the newer face authentication technology. Importantly, if a paper certificate is accepted, the bank manager has to record clear reasons why, make a recommendation, and log it in a special exception register.
So there are backup procedures. What happens when a pensioner sadly passes away? How are payments stopped? And how does family pension start?
When official notice of death with a death certificate is received, the original PPO usually already contains details about the family's entitlement to family pension. The widower, eligible children, including any disabled children entitled to lifelong pension.
So the entitlement is pre-recorded?
Often, yes. The family pension is then paid separately to each eligible family member, directly into their own bank accounts. If the bank hears about a death first, maybe not from the family, they're supposed to proactively contact the family and guide them on starting the family pension claim.
And what about overpayments? If pension was paid after death?
The manual covers recovery. Any overpaid amount is usually recovered from any balance left in the pensioner's account or from future family pension payments. This is based on a legal undertaking the pensioner gave when their pension started. Recovery is generally limited to 1/3 of the net payable amount each month, unless the family agrees to more.
Finally, on disbursement, there's a mention of customer service regarding incorrect payments.
Yes, it stresses keeping pensioners informed about any overpayments or incorrect amounts and how they'll be recovered. If an error is found and it originated with the bank or agency, the full overpaid amount should be immediately credited back to the EPFO's pension fund account, number 10.
Regardless of recovery from the pensioner.
Yes, the bank needs to credit it back straight away. Then, if recovery from the pensioner is needed, the bank adjusts their account balance or makes deductions from future payments, usually capped at that 1/3 limit, unless the pensioner consents to more.
That gives us a clear picture of the payout side. Let's now turn to how the whole scheme is funded and managed financially. Contribution and fund management. Where does the money come from?
Primarily, it's funded by mandatory contributions made by employers for their employees who are EPS members. Employers remit these contributions electronically, using the ECR system, directly into a specific account. EPF account number 10, the employee's pension fund.
Is there a deadline for these payments?
Yes, contributions for a particular month are due before the 15th day of the following month. The manual refers to detailed guidelines on the exact rate of contribution, basically. What percentage of the employer's total PF contribution gets diverted to this pension fund?
What happens if an employer fails to pay? Does the employee lose out on their pension?
No, and this is a really important protection. The manual clearly states that pension benefits due to a member or their family will not be denied or withheld just because the employer defaulted on contributions.
So the employee is protected?
Yes. The employers remain fully liable for the missing contributions, and they can also face penalties, damages for delays.
That's a crucial safeguard. How is this large pool of money in the pension fund actually managed and invested? It must be huge.
It is. The funds in account number 10, except for any government contributions, are invested according to rules set out in the main EPF scheme, paragraph 52. The central government notifies the allowed investment patterns.
Does EPFO have its own investment strategy?
Yes, they have a detailed investment manual approved by the Central Board of Trustees. And it's crucial to understand, a pension scheme's needs are different from a provident fund.
How so?
Pensions need steady cash flow for long-term payouts, often decades. Provident funds are usually lump sums at retirement. So the pension fund investment strategy has to be tailored for long-term wealth creation, using suitable assets, maybe dynamic allocation, all aligned with those long-term payout liabilities.
And the fund money can only be used for pensions?
Correct. Only for payments under the EPS scheme itself. Admin costs come from a separate account, though the cost of actually remitting the pension payments each month is charged directly to the pension fund.
Okay, and you mentioned an annual review of the fund's health?
Yes, the central government appoints a qualified valuer to conduct an annual actuarial valuation of the pension fund. This assesses its financial soundness and long-term sustainability. Based on the findings, the government can make adjustments, maybe changing contribution rates or even the benefits provided.
That leads us perfectly into the next topic, actuarial valuation. Can you expand a bit on the purpose of this annual exercise? Why is it done?
Fundamentally, the annual actuarial valuation is a health check, a rigorous assessment of the pension fund's financial strength and its ability to meet all its promises, both now and way into the future.
How does it do that?
It compares the fund's current assets against the estimated present value of all its future liabilities, all the pensions and benefits it expects to pay out. This uses established actuarial methods and makes informed assumptions about things like how long people will live, investment returns, salary growth, etc.
And the result can lead to changes.
Exactly. As we just touched on, if the valuation shows a potential shortfall or even a large surplus, it can trigger decisions about adjusting contribution rates or modifying the benefits offered by the scheme. It's all about ensuring long-term solvency.
What's the actual process followed for this valuation?
A professionally appointed actuary does the assessment. They compare the market value of the fund's assets against the estimated present value of all future payouts. This involves making those best estimate assumptions about mortality rates, withdrawal rates before retirement, investment returns, future salary increases, and so on. The core question is, does the fund hold enough assets now to cover all its expected future obligations?
Does EPFO itself play a role in this? Do they have in-house expertise?
Yes, they do. EPFO has an in-house actuarial cell. Their job is critical, collecting, managing, and analyzing the vast amount of data needed for the valuation.
So they handle the data?
Yes, and they also provide input on designing the contribution and benefit structures, and on the fund's investment strategy, working with the investment team. Data accuracy is paramount, so they liaise with the IT/IS division to ensure data quality.
What happens with the final report?
The pension division examines the detailed report from the external actuary. If they find issues or need clarifications, they can send it back for revision. Once finalized, the report goes to the Ministry of Labor and Employment for review and official approval.
It sounds like a very rigorous and vital process for the scheme's long-term health. The manual also briefly mentioned benefits on revaluation procedure and past reliefs granted.
Yes. Based on past valuations, the government has sometimes decided to give extra reliefs or enhancements to pensioners. The manual mentions one example, a one-year relief of 4% on the pension amount declared back in 1996 as an interim measure.
Is that just temporary?
It was extended and stayed in effect until March 31st, 2000. Importantly, this relief was calculated on the original pension amount when the PPO was first issued, not on any reduced amount if someone chose a return of capital option. And if the original pensioner died after 96, the relief was payable to their widower too.
Interesting. Does the manual show the fund's historical health?
It apparently includes a table summarizing the financial status from various past actuarial valuations, showing the valuer's name and whether a surplus or deficit was found each time. Gives a historical perspective.
It's good to see how these checks have influenced benefits over time. Finally, on valuation, there's a note about institutional initiatives to review benefits under EPS 95. What's that about?
This highlights that various committees and working groups have been set up over the years specifically to review the EPS provisions.
Why? To make changes.
Often, yes. The goal is usually to explore potential ways to enhance or modify benefits, considering things like the changing economy, society, and of course the findings from those actuarial reports. It shows an ongoing effort to keep the EPS relevant and sustainable.
That brings us to our final major section from the manual, administration and governance. Who's actually in charge of overseeing this whole massive scheme?
At the top level, the EPFO, which runs the EPS, is governed by the Central Board of Trustees, EPF. This is a statutory body set up by the government.
Who sits on this board?
It's tripartite, meaning representatives from the government, employers' organizations, and employees' unions. The Union Minister for Labor and Employment chairs the board, and its term is typically 5 years. They set the overall policy and make key decisions for EPFO and its schemes, including EPS.
Are there specific committees focused just on the pension scheme?
Yes, there's the Pension and EDLI Implementation Committee, or PEIC. Its main job is to continuously review how the EPS and the EDLI, the linked insurance scheme, are operating.
What do they look at?
Things like computerization efforts, how well pension disbursement is working, and considering any proposals for changes or improvements to either scheme. They act as a key advisory group to the main central board on pension and insurance matters.
What about the internal structure within EPFO itself? Who handles the day-to-day running of EPS?
At the head office, there's a dedicated pension division. They handle a wide range of crucial stuff: policy formulation for EPS, implementation, legal issues, proactive initiatives to improve the scheme, and monitoring its overall performance.
Is that division broken down further?
Yes, it's structured into several specialized sections. For example, sections focusing on policy, on processing those higher wage pensions, handling legal work for both EPS and EDLI, developing proactive efforts, ensuring pension continuation, managing grievances, and overseeing the financial management side of pension payments.
And how does that structure at head office translate down to the regional offices where claims are actually processed?
At the regional office, RO level, processing a pension claim involves close teamwork between the accounts branch and the dedicated pension branch.
How do they split the work?
The accounts branch usually does the initial heavy lifting, verifying service history, wage details, and preparing the input data sheet, IDS,
Right.
with all that verified info.
Right, they prepare the data.
Right. Then that comprehensive IDS goes to the pension section within the RO. The pension section takes it from there. They handle the final receipt and processing of the claim, authorize the actual pension amount, generate the draft and final PPOs, manage transfers between regions, and oversee the actual disbursement through local banks. They also handle customer service stuff like pension adelats for grievances.
So a clear workflow. Head office for policy, regional offices for direct implementation and service. Are there mechanisms to monitor how well it's all working? Any performance tracking?
Yes, definitely. There are robust monitoring systems at both RO and head office levels, heavily using MIS dashboards, management information systems.
What do these dashboards track?
Real-time data on key things. How many claims of different types are pending? The status of digital life certificate submissions, progress on higher wage applications, how many people have filed e-nominations, and the results of proactive settlement drives like PRIAs.
So they can spot bottlenecks.
Exactly. These tools help analyze workloads, identify delays, and monitor overall settlement progress. Plus, there are internal audits to check the accuracy of pension calculations and the system's integrity. Supervisors at different levels also conduct regular reviews, and the manual lists key court judgments related to EPS, which provide important legal context for administration.
Wow. This has truly been an incredibly detailed exploration of the Employees' Pension Scheme, 1995, all drawn from that Manual of Accounting Procedure. We've covered so much ground.
We really have.
From eligibility, the different benefits, the crucial roles of age, service, salary, the complexities around higher wages, the nitty-gritty of claims processing, disbursement funding, right through to actuarial checks and governance.
Indeed. The EPS 1995 really stands out as a comprehensive and vital system. It's designed to provide essential financial security, not just in retirement, but also supporting families through various challenges. And as digging into this manual shows, it operates with a very detailed, intricate set of rules and procedures.
It really hammers home how important it is for everyone involved, members, potential beneficiaries, the administrators, to have a solid grasp of these details. It's not simple stuff.
Absolutely not. And given how complex these large Social Security schemes inevitably are, staying informed about your rights, your responsibilities, and the benefits you might be entitled to, it's just paramount.
Yeah.
Making this manual's content more accessible was really our aim today.
Definitely. So considering all these detailed procedures and the range of benefits we've outlined today, what further questions does this deep dive into the EPS 1995 raise for you, our listener? Thinking about its ongoing implementation and its overall impact in ensuring Social Security for so many people across India, it's certainly a lot to mull over. Thank you for joining us for this detailed look into the Employees' Pension Scheme.
You're here for clarity, for understanding, and, well, maybe a shortcut to some pretty crucial knowledge. Welcome to this deep dive. Today, We're really getting into a vital piece of legislation, something that touches so many lives. The Employees Deposit-Linked Insurance Scheme, 1976.
EDLI.
Think of this maybe as your personal audio briefing. We're aiming to pull out all the key details, explain them, so you don't have to wade through those dense official documents yourself.
Exactly. And we've gathered all the essential sources. We've got the original 1976 scheme document itself, detailed briefing notes, those helpful FAQs, even a study guide. Basically, everything needed to really unpack this.
So the mission here?
Our mission, it's simple, but I think crucial. We want to deliver every single need-to-know aspect in plain, straightforward English, really clear.
Make it understandable.
Exactly. So by the end of our chat, you'll have a solid grasp of this important scheme, no matter, where you're starting from.
Okay, great. Let's dive right in then, to the heart of it. What exactly is the Employees Deposit-Linked Insurance Scheme? And when did it all begin?
Okay, so the full name is, like you said, the Employees Deposit-Linked Insurance Scheme, 1976. And it officially kicked off on August 1st, 1976.
August 76, okay.
But what's fundamental, really, is its legal basis. It comes from Section 6C of the Employees Provident Funds and Miscellaneous Provisions Act, 1952.
Okay. So it's tied into the main EPF Act.
Directly connected, yeah.
Yeah.
Part of that whole framework.
Got it. So it's linked to the Provident Fund Act, but what's the main reason it exists? I mean, what's the core benefit it aims to provide, for you or someone listening?
Right. The primary goal is to provide a financial assurance benefit. Now, what that means in practical terms is it's a payment, and it's directly linked to the average balance in an employee's Provident Fund account.
Okay.
This benefit, it becomes payable if an employee sadly passes away while they're still an active member of the fund.
Right. So in a really difficult time, this scheme kicks in. Is this instead of the money they've saved in their PF, or is it something extra? Because that sounds like a really important difference.
It's absolutely crucial, yeah. This assurance benefit is in addition to the Provident Fund savings that the employee has built up over their working life.
Okay.
It really acts as an extra safety net for their family, during a very challenging period.
That makes a lot of sense. An extra layer.
Yeah.
So who exactly does this apply to? Is it universal? Does it cover every single worker in India?
Not quite universally, no. Generally speaking, it applies to employees who work in factories and other kinds of establishments that are already covered by the main EPF Act, 1952 one.
So if you're covered by EPF, you're likely covered by this too?
Generally, yes. But there are exceptions.
Okay, are there any specific ones we should know about? Any groups definitely not covered?
Yes, there's one specific exclusion mentioned right from the start. Tea factories.
Tea factories.
Yeah, specifically those located in the state of Assam. For whatever reason, perhaps specific to that industry or region back in 76, they're carved out. They aren't covered by this particular insurance scheme.
Interesting. Okay, so when we hear ACT, that's the EPF Act, 1952. And the assurance benefit, that's this death-linked payment connected to the PF balance.
You got it.
Clear enough. Now,
Yes.
Administration, who's actually running this whole system? Who manages it day to day?
Okay, the main authority here is the Central Board. This is a body that was already set up under Section 5A of the EPF Act itself.
Right.
They hold the primary responsibility for administering this whole deposit-linked insurance scheme.
And are there any other groups involved, maybe advisory committees at a local level helping out?
Yeah, there is. There's a regional committee that was set up under the main EPF scheme back in 52 as well.
Okay.
Their role is more advisory. They give advice to the Central Board on different aspects of running this insurance scheme.
Like what specifically?
Well, two key areas they focus on are, one, keeping an eye on contribution recovery, making sure the money's coming in, both from places that have exemptions under Section 17 and those generally covered, and two, ensuring that any legal cases related to the scheme get resolved promptly, sort of monitoring the financial and legal health regionally.
Got it. So they're keeping tabs regionally. What about the more day-to-day stuff, practical running of the scheme? Who handles that?
Right. So the Central Board can delegate some powers. They can pass a resolution authorizing their chairman or the commissioner, or maybe both, to handle certain tasks,
Such as?
like approving necessary spending for supplies and purchases needed for the insurance fund. But of course, these authorizations always come with specified financial limits, checks and balances.
Right, makes sense. And staffing. What about hiring people to actually run the scheme?
The Central Board can also authorize the chairman or the commissioner to appoint officers and employees. There's some specific high-level positions mentioned in the Act they can't appoint, but otherwise, they can basically build the administrative team needed to manage the scheme effectively.
Sounds like the commissioner has a pretty big role in all this.
Absolutely. The commissioner also has their own independent administrative and financial powers, but mainly for routine operational costs.
Like,
Things like unforeseen expenses, buying necessary supplies, paying for services required for the insurance fund. As long as it's within the budget allocated and the limits the central board sets, they can approve that kind of spending.
okay, so we've got who it applies to, who's in charge. Now, the money. How is this assurance benefit actually funded? Where does the cash come from? Who pays in?
Right, the funding, it comes from two main sources. The employers and the central government.
Not the employees.
No, that's important. The employees themselves don't make any direct contributions to this specific insurance scheme. Their contribution is to the main PF.
Okay, employers and the government. How are their contributions worked out? Is it a flat amount or does it link to employee earnings?
It's linked to earnings. Specifically, it's calculated based on the employee's monthly pay. That includes their basic wages, dearness allowance, and that includes the cash value of any food concession they might get, plus any retaining allowance, if that applies.
So based on what they actually earn each month.
Exactly. Whether they're paid daily, weekly, fortnightly, or monthly, it's based on those earnings components.
Is there a cap, a limit on how much of someone's salary is counted for this calculation?
Yes, and this is a crucial detail. There's a ceiling. Even if an employee earns more than 15,000 rupees a month, the contribution payable by both the employer and the central government is capped. It's limited to the amount that would be payable on a monthly salary of 15,000 rupees.
So 15,000 is the magic number for contributions?
For contribution purposes, yes, that's the ceiling on the monthly pay, including all those bits: basic, DA, retaining allowance, food concession value.
Got it. So there's a cap. When do employers actually have to cough up their share? When do they pay?
Employers need to pay their contribution, plus any admin charges, into the insurance fund within 15 days of the close of every month.
15 days.
And it has to be done properly. Separate bank draft, check, or maybe cash remittance, following the procedures the commissioner sets out. The employer also has to cover any bank charges for sending the money.
And the central government's contribution, when does that come in?
The central government credits its share to the insurance fund as soon as possible after the end of each financial year. So it's more of an annual thing from the government side.
Right. What if an employer messes up? What if they're late paying their contribution? Are there penalties?
Oh yes, there are definitely provisions for recovering damages if they default. If an employer fails to pay their contribution or any other charges on time, they can be charged damages. The penalty is 1% of the amount they owe per month, or even part of a month, for the whole time they're late.
1% per month, that could add up fast.
It really could. It's a strong incentive to pay on time.
Is there any way out? Can employers get some relief from these penalties if they have a genuinely good reason for being late, like real difficulty?
Yes, the central board does have the power to reduce or even waive these damages, but only in specific, quite serious circumstances.
Such as?
Things like a change in management, maybe the business was transferred to a workers' cooperative, or if a struggling industrial company merges with another one.
Okay.
Also, if the BIFR, that was the Board for Industrial and Financial Reconstruction, set up to help sick companies if they recommended a waiver as part of a revival plan, then a full waiver might be possible.
And reductions.
In other cases, depending on the specifics, they might grant a reduction, maybe up to 50%, but not a full waiver usually. So there's some flexibility, but mainly for really challenging situations.
Right. Now, a really fundamental question for employees listening. Can my boss just deduct their contribution for this scheme from my wages?
Absolutely not. No way. The scheme is crystal clear on this. Regardless of any contract or agreement that says otherwise, the employer is not allowed to deduct their contribution from the employee's wages.
Okay.
They also can't try to recover it in any other way. This is a key protection. The employer bears the full cost of their share.
Definitely good to know. So employers have this financial duty. What else do they have to do under this scheme? Sounds like there could be a fair bit of admin.
You're right, there are several key duties. First, way back when the scheme started in '76, within 15 days, they had to send in a big consolidated return.
What was in that?
Details of all eligible employees, their insurance scheme number, their PF savings up to that point, and copies of their PF nominations. It was a big initial data dump.
A one-off. What about ongoing stuff, month to month?
Okay, ongoing. Within 15 days after the end of each month, employers have to send in a return using Form 5 from the EPF scheme.
Form 5, what's on that?
It lists any employees who became newly eligible for the insurance fund that month, along with copies of their nominations. It also lists anyone who left the job that month.
And nothing changed. No joiners, no leavers.
Still have to send it. Even if it's a NIL return, they must submit it. Regular reporting is key.
Keeping those records up to date is obviously vital. Anything else monthly?
Yes. Within 25 days after the month ends, they also need to submit a monthly abstract. This is basically a summary.
A summary of what?
The total wages paid to all members that month, on which contributions are due, and the total employer contribution paid for all those members for that month.
Okay. Beyond just sending info, do employers handle the money itself in any way other than paying their share?
Well, they have to maintain proper accounts relating to the contributions they make, following whatever guidelines the central board issues.
Right.
And importantly, they have a duty to assist the central board in making payments out of the insurance fund when benefits are due to be paid. They help facilitate the payout process.
And with everything going digital, is there an electronic filing requirement too?
Absolutely. Employers now have to submit electronic versions of all those returns, the initial one, the monthly Form 5, the monthly abstract, and whatever specific format the commissioner lays out. It helps streamline things.
Makes sense. And audits. If the authorities want to check things, what does the employer have to do?
They have to produce their records. Any relevant registers, accounts, documents, they must make them available for inspection whenever asked by the commissioner or an authorized officer or an inspector. Transparency is built in.
And finally, forms. If an employee or their family needs a form for a claim or something, who provides those?
The commissioner is responsible for supplying the necessary forms to employers free of charge. Employers can request them when they need them for genuine scheme purposes.
Okay, so funding covered, employer duties covered. Now, let's track the money. How is it actually managed? You mentioned an insurance fund. Is that just one big pot?
Not quite. The scheme actually sets up two separate accounts, which is good for clarity. First, there's the Insurance Fund Central Administration account.
Okay, what's that for?
That's where the administrative charges go, the bits paid by employers and the government specifically to cover running costs. All the operational expenses for managing the scheme come out of this account.
So admin costs separate. What's the second account?
The second one is the main one, the Deposit-Linked Insurance Fund account. This is where the actual employer contributions and the central government's contributions for the insurance benefit are credited.
And benefit payouts come from here.
Exactly. All the actual assurance benefit payments made under the scheme are paid out of this account. So you have a clear separation, one for admin, one for benefits.
That makes sense for keeping track. What happens to the money while it's sitting in these funds? Is it invested?
Oh yes, definitely invested. Before April 1997, all the money in the insurance fund was basically deposited with the central government in the public account. And it earned a guaranteed minimum interest rate 8.5% per year.
Pretty decent rate back then. Did that change after 97?
Yes, it did. From April 1st, 1997 onwards, the money credited to the insurance fund is invested based on the investment patterns that are officially notified for the main EPF scheme under paragraph 52.
So potentially a wider range of investments now?
Potentially, yes, following the same rules as the main Provident Fund investments.
And any earnings from these investments, where do they go?
They go straight back into the fund. All the interest, rent, any other income, plus any net profits or losses from buying and selling investments. It all gets credited or debited directly to the main insurance fund account. Helps the fund grow over time.
Right. And can this main insurance fund be dipped into for anything other than paying out these assurance benefits we're talking about?
Generally, no. The main insurance fund, not the admin account, can't be used for anything else unless the central board gives it specific prior approval for some other expenditure.
Okay.
And the fund itself is managed by officers who are specifically authorized by the central board to handle these financial operations.
Right. Let's get to the core benefit amount now. This is probably the most crucial part for anyone listening, for employees and their families. How is the actual assurance benefit calculated? You mentioned it's evolved.
You're right, it has evolved, and significantly, to offer better support. Originally, the benefit was very directly tied to the average balance in the deceased employee's PF account.
How far back did they look?
Usually the 12 months just before their death, or their whole period of membership if that was shorter. There was an initial setup with like a cap and maybe a percentage for amounts over a certain threshold. The source materials hinted at maybe 50,000 one with a euro 1,000 ceiling initially.
But that's changed.
Oh yes, big enhancements since then. The benefit now can be much, much more significant.
Okay, tell us about these enhancements. What's the current calculation method, especially for someone who's been working steadily for a while? That's probably many listeners.
Right. So for an employee who is in continuous employment for the 12 months right before the month they passed away, the benefit is now calculated as the higher of two different methods.
Higher of two. Okay, what's the first method?
The first calculation looks at their average monthly wages during those last 12 months. But there's a cap on the wages considered again, that 15,000 rupees per month figure.
Okay, average wages capped at 15K, then what?
That average wage figure is multiplied by 35.
35 times average capped wages.
Yes. And then added to that is 50% of the average balance they had in their Provident Fund account during those same preceding 12 months.
Half the average PF balance.
But there's a limit on that PF balance part too. It's capped at 1,75,000 rupees.
So 35x AVG capped wages plus 50% of AVG PF balance up to 1.75L.
Exactly. And what's really impactful here for you listening is seeing how this shifts the focus. It's not just about savings anymore. It strongly considers recent earnings too. Provides a more immediate safety net.
Okay, that's method one. What's the second option they compare it against? You said it's the higher of two?
The second option is simpler. It's just the benefit calculated using that original method we talked about first, the one based purely on the average PF balance.
Oh, okay.
So they calculate it both ways, and the employee's family gets whichever amount is higher. They ensure the family gets the better deal out of the two calculations.
That's good. Are there minimums and maximums now? Overall limits?
Yes, very important ones. Regardless of which calculation method gives the higher figure, the final assurance benefit cannot be less than 2,50,000 rupees.
Minimum 2.5 lakh. Wow.
And it cannot exceed 7 lakh rupees.
Max 7 lakh. Okay, so a guaranteed floor of 2.5 L and a ceiling of 7 L. That's a significant range.
It really is. Provides a substantial level of potential support.
Were there any other increases? Any further boosts mentioned?
Yes, there was another enhancement mentioned. The scheme now says that the benefit amount, whichever one is calculated as higher using those methods, is then further increased by an additional 20%.
An extra 20% on top.
Yes. On top of the benefit calculated by either the average balance method or that enhanced wage plus PF method. It's another layer of financial aid.
Wow. Okay. So that's a pretty significant final amount, potentially. What about tricky situations like part-time workers, maybe someone contributing to PF from multiple jobs?
Good question. For part-time employees who were members of the fund through more than one job, more than one factory or establishment, the benefit is calculated based on the average of the total balance across all their PF accounts during those preceding 12 months.
Ah, so they aggregate it.
Exactly. It ensures their entire PF contribution history is factored in when working out the assurance benefit.
This is much clearer now. It considers service, recent pay, overall PF savings, has minimums and maximums, plus that extra 20%. Okay. Who actually gets this money when an employee passes away?
The primary person or people are the nominee, the employee designated in their Provident Fund nomination.
The PF nomination counts for this too.
Yes. That same nomination form is considered valid for this insurance scheme as well. So the assurance amount goes to whoever they named on their PF form.
Makes sense. What if they didn't nominate anyone? Or maybe the nomination is old, incomplete, doesn't cover everything.
Right. If there's no nomination, or it's invalid, or maybe it only covered part of their PF, then the entire amount, or the part not covered by the nomination, becomes payable to the members of the employee's family, and it's shared equally among them.
Okay, family gets it. Are there rules about which family members?
Yes, there are. And there are also specific exclusions under certain conditions.
What kind of exclusions? Who might not get a share?
Okay, the scheme says no share goes to sons who've reached the age of majority, adult sons, or sons of a deceased son who are adults, also married daughters whose husbands are alive, and married daughters of a deceased son whose husbands are alive. if there's any other family member available besides these specific groups.
Okay, so it seems to prioritize potentially more dependent family members if they exist.
That seems to be the idea, yes. If there's no clear nomination, it defaults to family, but prioritizes spouses, minor children, unmarried daughters, dependent parents, that sort of thing, over adult sons or married daughters with living husbands, if those other relatives exist.
Are there any other really specific rules about family shares?
Yes, there's one for widows and children of a son who died before the employee.
Okay.
Basically, the widows and child of that predeceased son together, they only get the share that their deceased husband father, the employee's son, would have gotten if he'd lived and was still a minor when the employee died. It splits his potential minor share amongst his dependents.
That's quite detailed, covers a specific scenario. What if there's no nomination and no surviving family members as defined by the scheme? Who gets it then?
In that rare case, where neither the nomination rules nor the family rules apply, the whole assurance benefit goes to the person who is legally entitled to inherit it, according to inheritance laws.
Okay, the legal heir.
Yeah.
What about difficult circumstances, suspicious deaths?
Yes, the scheme addresses that. If someone who is entitled to get the benefit is formally charged with murdering the employee or helping with the murder,
Right.
their claim is put on hold, suspended, until the criminal case is finished.
And if they're convicted?
If they're convicted of the murder or aiding it, they're disqualified. They lose their share, and it gets divided among the other eligible family members.
And if acquitted?
If they're found not guilty, then their share is payable to them as normal.
Makes sense. One more thing on eligibility. What about a child born after the employee passes away?
Good point. The scheme explicitly covers this. An employee's child born after their death, as long as they're born alive, is treated exactly the same as a child who was born before the employee died. They are fully eligible for a share of the benefit.
That's good to know. Ensures posthumous children are included. Okay, we know who gets it. What's the actual process for claiming it? What do the family members or nominees need to do?
The claimant nominee, family member, whoever is eligible, needs to submit a written application to the commissioner.
Is there a specific form?
Yes, it has to be in the specific form prescribed by the commissioner. And, importantly, it should normally be submitted through the employer of the deceased employee. The employer acts as a conduit.
The employer helps facilitate. What if the beneficiary is a minor, under 18? Or maybe someone legally unable to manage their affairs.
Right. If the beneficiary is a minor, or if they're legally incapacitated, say, due to a mental health condition, the payment is made according to the rules already set out in the main EPF scheme, 1952.
And those rules cover guardians and such.
Exactly. They have specific procedures for paying guardians or legal representatives in those situations.
How does the money actually get paid? Is it a check in the post?
While that might still be possible, the scheme strongly prefers and encourages electronic payment. Digital funds transfer directly into the beneficiary's bank account.
Any bank.
Any scheduled commercial bank, yes. Or even into a post office savings account, if the beneficiary prefers that. It's just faster and more secure.
Definitely. Now, timing. This is critical. Losing someone is awful. Delays with money just add stress. What's the expected time frame for the family to get this benefit?
This is a really crucial point in this scheme. It sets out a strict timeline. Claims that are complete, meaning they have all the right documents and information, should be settled, and the money paid within 20 days from the date the commissioner receives that complete application.
20 days. That's actually quite fast.
It's meant to provide timely support, yes.
What if there's a problem? Missing document, wrong info on the form. Does that just stop the clock?
No, if there are issues, deficiencies, missing bits, the commissioner has to record these problems in writing and tell the applicant about them within that same 20-day window from when they first got the application.
So they have to respond quickly, even if it's incomplete.
Yes. It ensures the claimant knows what's wrong quickly so they can fix it and get the claim processed.
Yeah.
No sitting on it indefinitely.
Okay, but what if the claim is complete, everything's fine, but the commissioner still doesn't pay within those 20 days, and there's no good reason? Are there consequences for that delay? Because 20 days sounds like a promise.
Yes, there are serious consequences. If the commissioner fails without a sufficient, justifiable reason to settle a complete claim within 20 days,
Yeah.
they become liable for that delay. Penal interest can be charged,
Penal interest, how much?
12% per annum. charged on the benefit amount for the whole period of the delay.
Wow, 12%.
And get this, that penal interest amount might even be deducted from the commissioner's own salary.
Seriously?
That's what this scheme provides for. It's a very strong protection for beneficiaries, pushing for efficient processing and no unnecessary delays.
That is a powerful incentive. Okay. Moving on slightly, ongoing admin. Are there specific rules about keeping records and reporting on how the scheme's doing overall?
Absolutely. The commissioner has the power, with central board approval, to specify exactly what registers and records need to be kept about the employees covered. They can also decide the format for things like ID cards or tokens, if needed, to identify employees or beneficiaries. And they can set out any other procedures needed for paying the benefit, including maybe periodic checks to make sure everything's correct.
And overall reporting. Does someone check how the whole scheme is performing?
Yes. The central board has to prepare an annual report. It covers how the scheme worked during the previous financial year.
When is that done?
It needs to be approved by the board itself before December 10th each year, and then submitted to the central government by December 20th. So there's regular oversight and reporting upwards.
Okay, now exemptions. We touched on this earlier, the Assam tea factories being out. But can individual employees or maybe whole companies get exempted?
Yes, they can, under specific conditions. If an individual employee is already getting life assurance benefits through their employer,
Right.
maybe linked to their PF, maybe separate, and if those benefits are genuinely more favorable overall than what EDLI offers, and the employee doesn't have to pay any extra contribution or premium for them.
Okay, better benefits at no extra cost to the employee.
Exactly. In that case, the commissioner can grant an exemption to that individual employee.
What about whole companies or groups within a company?
Similar principle. The Central Provident Fund Commissioner, or sometimes an authorized additional CPFC, can grant an exemption to a whole class of employees if they, as a group, have life assurance benefits that are better than EDLI, again, without employees having to pay extra. There's a specific application form for that group exemption.
If a company gets this exemption, are they totally off the hook regarding EDLI admin?
Not entirely. Even with an exemption, the employer still has duties. They need to maintain specific accounts for these exempted employees, submit returns as required, allow inspections, pay any inspection charges, and manage investments according to government instructions.
So they still have compliance duties related to their alternative scheme.
Exactly. The oversight continues, just focused on their exempted arrangement.
Can someone who's exempted change their mind later? Can an employee or a group decide they do want the EDLI cover after all?
Yes, they can. An individually exempted employee can apply to come back under EDLI. And a whole class of exempted employees, or at least a majority of them, can also request to rejoin the main scheme.
Is there a limit to switching?
Yes. You generally only get one shot at opting out and opting back in for each account. You can't keep flipping back and forth.
Okay. Our notes also mention Section 17(2)(a) of the Act. How does that fit in with exemptions?
Right. That section provides some flexibility. Basically, if a company has applied for a broader exemption under Section 17(2)(a) of the main EPF Act, which covers both PF and eventually insurance, while that application is still being processed, the commissioner can relax some of the EDLI scheme's rules for that company temporarily. It eases things while they wait for the main exemption decision.
And just like regular companies, do these exempted establishments also have to submit things electronically?
Yes, they do. Every employer with an exemption still needs to send electronic returns related to their exempted employees to the commissioner using the prescribed format. Consistent data flow is needed.
Okay. Something else mentioned was the Employees Enrollment Campaign 2017. What was that about, and how does it connect to EDLI?
Ah, yes, the 2017 campaign. That was an initiative to encourage employers to declare employees who hadn't previously been enrolled in PF and related schemes.
Right.
And it had a specific impact on EDLI damages. For establishments that declared employees under this campaign,
Yeah.
there was a special, much lower rate for damages if they had defaulted on EDLI contributions for the period between April 1st, 2009 and December 31st, 2016.
How much lower?
Instead of the usual 1% per month penalty, it was fixed at just 1 rupee per year for that specific period, but only for payments related to valid declarations under that 2017 campaign.
1 rupee a year. That's basically nothing.
It was a huge incentive to come clean and enroll previously undeclared employees, getting them into the Social Security system without facing massive historical penalties for that specific period.
A major amnesty, essentially, for that period's EDLI defaults if they participated. Got it. Finally, punishments. What happens if employers just don't follow the rules? We talked about late payment penalties, but what about other violations?
The scheme lists several things that can attract punishment, like illegally deducting the employer's contribution from employee wages.
Right.
That's a big no-no.
Right, well,
Failing to submit returns or submitting false or misleading returns, obstructing an inspector or official who's trying to do their job under the scheme, failing to produce records when asked for inspection.
so non-cooperation and false information.
Exactly. Or just generally breaking any other rule or requirement of the scheme. All these can lead to penalties under the relevant sections of the law.
And what kind of penalties are we talking about? Fines? Jail time?
It can be serious.
Yeah.
The general penalty for breaking the scheme's rules is imprisonment for up to 1 year or a fine up to 25,000 rupees, or potentially both.
So real consequences.
Yes, it underlines that compliance with the EDLI scheme is taken very seriously.
Well, I have to say, you've given us an incredibly detailed walkthrough, a really comprehensive understanding of the Employees Deposit-Linked Insurance Scheme, 1976. It's clear this is a really significant safety net.
Indeed. And that was the goal, to provide you, the listener, with that thorough, clear explanation, to act as that audio guide through these important rules.
Yeah.
I think the fundamental takeaway, the thing to really remember, is that EDLI is this vital financial cushion for families when a Provident Fund member passes away. It's a substantial benefit on top of their PF savings. And there are these clear, defined processes for how contributions work, how benefits are calculated and paid, and what everyone's responsibilities are: employers, administrators, everyone.
Thinking about all the details we've covered, the calculations, the timelines, the penalties, the exemptions, it really does highlight how crucial these kinds of Social Security measures are, doesn't it?
Absolutely.
It makes you wonder, considering everything we've discussed, what aspects of a scheme like this really make the biggest difference on the ground? Or maybe what areas might still need, further thought or refinement as we look at the bigger picture of employee welfare and financial security today. It definitely gives you food for thought.
It certainly does. It's a complex but vital part of the system.
Thank you so much for breaking it all down for us on this deep dive.
My pleasure.
Welcome to the Deep Dive. Today, we're really getting into a cornerstone of India's social security system.
That's right. We're looking at the Employees Deposit-Linked Insurance Scheme, the EDLI, from 1976.
Exactly. And look, you shared the original documents with us, so our mission today is essentially to act as your audio guide through it all.
We want to pull out the crucial bits, make it really clear how this scheme works, how it provides that financial backup for families if an EPF member passes away.
It's been part of the main EPF Act since '52, so it has a long history.
Very long history.
Oh.
And it covers folks in the organized sector.
So what we'll do is unpack the key things, like who is eligible, how the funding works, the contributions.
Yeah, the benefits, how they're calculated, the claim process, which can seem a bit daunting sometimes.
Right, and also touch on things like exemptions, fund management, basically the need to know stuff.
We'll sift through it, give you the core facts, maybe even a few surprising details, but without burying you in jargon. A clear overview.
Perfect. Let's get straight to it then. When did EDLI actually start?
Okay, so the official start date was August 1st, 1976.
1976, okay.
And its main goal, right from the start, was this insurance cover tied to the Provident Fund balance for members who die while they're still employed.
And it's linked directly to EPF membership, isn't it?
Absolutely. If you're covered by the EPF Act in 1952, generally you're covered by EDLI. It applies to, pretty much all factories and establishments under that act.
Unless. There's always an unless, isn't there?
Yes. Unless the establishment has been specifically granted an exemption from the EDLI scheme itself.
Right.
That's important. If they're exempt, these rules don't apply there.
Got it. Okay, contributions. This is key. Who pays into this fund? Is it like PF where employees contribute?
Good question. No, employees don't contribute directly to EDLI. The money comes from the employer.
Solely the employer.
Primarily, yes.
Right.
Currently, the employer puts in 0.5% of the employee's basic wages, plus dearness allowance and retaining allowance, if that applies.
And that 0.5% rate, when did that start?
That specific rate kicked in from November 16, 1995.
Okay. Is that 0.5% calculated on the employee's entire salary?
No, there's a ceiling. The contribution is calculated on wages up to a maximum of 15,000 rupees per month.
Right, 15,000. So even if someone earns, say, 50,000, the employer's EDLI contribution is based only on that first 15,000.
Exactly. That's the current wage ceiling for this specific contribution.
Now, you mentioned 1995. The scheme started in 76. Was the contribution structure different back then?
It was, yes. Quite different, actually. So 1976 up until November 15th, 1995, it was a shared responsibility.
Shared how?
The employer paid 0.25%, and the central government also paid 0.25%.
Oh, interesting. So the government used to match the employer's contribution?
Precisely, but that stopped. From November 16th, 1995 onwards, the government contribution ceased, and the employer took on the full 0.5%.
That's a significant shift. How do employers handle these payments now? I assume it's all digital.
Oh, completely. Employers use the unified portal, the employer portal. They generate an ECR, the electronic child income return, validate it, and make the payment online. It's quite streamlined now.
What about administrative costs? Does the employer pay extra fees for running this scheme?
Well, not anymore, not for the EDLI scheme itself. Since April 1st, 2017, there are no administrative charges payable by employers for EDLI.
So the 0.5% is basically it for most employers.
So the scheme contribution, yes. However, remember those exemptions we mentioned.
Ah, right. The establishment's running their own schemes.
Exactly. Those establishments, the ones exempted or granted relaxation, they do have to pay inspection charges, presumably to cover the cost of oversight for their alternative schemes.
Makes sense. Did everyone used to pay admin charges?
Yes. Historically, there were admin charges, but they were gradually reduced and then waived. Inspection charges for exempted places also change over time, but they still exist. The current rate, I think, is quite low, around 0.0005%,
Right.
set back in 1989.
Okay, let's shift to the beneficiary side. The most critical part, really. If a member passes away, how does their family actually claim this assurance benefit? What's the drill?
Right. The beneficiaries, the family members, need to submit a claim using either Form 5 IF for Insurance Fund or the Composite Claim Form, the CCF.
Form 5IF or CCF, online or offline?
Both options are usually available. They can submit it online via the portals or fill out a physical form and submit it offline. The commissioner sets out the exact procedure.
And who gets the money? Is it automatically the spouse or?
Generally, it follows the Provident Fund rules. The person or persons entitled to receive the deceased member's PF accumulation are usually the same ones who receive the EDLI assurance benefit.
So the EPF nomination is key here too.
Very much so. It aligns the beneficiaries for both EPF and EDLI, simplifying things for the family.
Now the benefit amount itself, it's linked to the PF balance, you said. How exactly is that average balance worked out?
Okay, calculating the average monthly balance is crucial. It looks at the total amount in the member's PF account for the 12 months right before the month they died.
Total amount meaning?
Meaning both the employee's share and the employer's share of PF contributions. And this includes contributions that were due for that period, even if maybe the employer hadn't actually paid them yet. Plus, crucially, any interest earned.
So even unpaid dues count. That's important.
Yes,
Yeah.
it protects the family. It's
Yeah.
based on what should have been there. And if the member was part of the fund for less than 12 months, the average is just calculated over their actual period of membership. Voluntary PF contributions are also included in this balance.
I see. And there's a specific way to calculate this?
Yes, the system generates a worksheet in a format the commissioner prescribes to ensure the calculation is done correctly for sanctioning the benefit.
Okay, so the form submitted, the average balance is calculated. What happens next in the process?
Well, the claim processing for EDLI, using that Form 5 IF or CCF, is pretty similar to handling a regular EPF withdrawal claim.
But with some EDLI specific checks, I imagine.
Definitely. A very important first step is to check if that particular establishment, or maybe that class of employees, had an exemption from the EDLI scheme back in 1976. Can't process an EDLI claim if they weren't covered, right?
Obviously. What else do they verify?
They verify the claimant is the rightful person, according to the nominations or family rules, that all the conditions are met, and they double-check the date of death against the employer's records in the system. Just basic due diligence.
You mentioned exempted establishments earlier. Is the process different if the claim comes from one of those?
Slightly, yes. For exempted establishments, the claims tend to be processed for settlement quite quickly after they're received, often without waiting for an initial check by an EPFO deputing officer.
Faster then.
Initially, yes,
Yeah.
but checks still happen later, and employers of these exempted places can actually see the settlement details for their employees' EDLI claims via their online logins.
Right. Let's get to the actual benefit amount. The payout, we know it's a lump sum. How is that sum determined today?
Okay, the assurance benefit. It's a one-time payment, correct? Historically, there used to be a rule about needing a minimum average balance, but that was scrapped for deaths happening from April 1st, 1993 onwards.
Good to know. So what's the formula now? It sounds like it might be a bit complex.
It's actually designed to give the better of two calculations to provide a more robust benefit. This current formula applies from April 28th, 2021.
Okay, what's the first option?
Option 1 is, take the average monthly wages the person earned in the 12 months before death, capped at 15,000 rupees per month, multiply that average wage by 35. Then, add 50% of the average balance in their PF account. But that added 50% part is capped at 1,75,000 rupees.
Okay, average wage times 35 plus half the average balance up to the limit. And the second option?
Option 2 is simpler. It's the average balance in the PF account plus an additional 40% of the amount by which that average balance exceeds 50,000 rupees. Though this additional part is capped at a maximum of 1 lakh rupees.
Average balance plus 40% of the balance over 50K up to a limit. And the family gets?
Whichever of those two calculations gives the higher amount. That's the assurance benefit payable.
So it tries to account for both recent earnings and accumulated savings.
Exactly. It provides a safety net, whether someone had high recent wages but maybe a lower balance, or vice versa, within those caps, of course.
What about people in less standard work situations, like seasonal workers, or someone on unpaid leave when they pass away? Are they still considered in service?
Generally, yes. For seasonal workers, if they die during the off-season but their name is still on the company's official list, the muster roll, they're usually considered to have died in service.
Even if they weren't getting paid then?
Correct. Similarly, if someone is on leave without pay or absent for some other valid reason, but they are still officially employed, still on the rolls on the date of death, the assurance benefit is typically payable, assuming other conditions are met.
So the employer not contributing during that specific unpaid period doesn't automatically disqualify them?
Right. The key is the formal employment status at the time of death. It offers broader protection.
That's really important clarity. Okay, nominations. How does an employee make sure this benefit goes to the right person?
The best way, and the way EPFO strongly encourages now, is the online e-nomination through the member portal. It covers PF, pension, and EDLI all at once.
E-nomination is preferred. But what if someone only has an old paper nomination?
If there's no e-nomination, a valid physical nomination form submitted before death, which the employer or EPFO has, can still be used as long as it meets all the rules.
Okay, that's good backup.
And to make it easier, any valid nomination made for the EPF scheme or for an exempted PF trust is automatically considered the nomination for EDLI too. No need for separate forms.
That's sensible. What if there's simply no nomination? Or it only covers, say, half the amount?
Right. If there's no nomination or it's incomplete, the EDLI amount, or the remaining part, is paid to the family members in equal shares.
But family has a specific definition here, doesn't it?
Yes, a very specific one under the rules. It generally includes spouse, minor children, dependent parents. But there are exclusions like adult sons or married daughters whose husbands are alive are typically excluded if other closer family members exist.
It sounds quite detailed.
It is. It prioritizes widows and minor children. If, after applying the exclusions, no one else is eligible, then those initially excluded might become eligible. It's a waterfall approach.
What about a really difficult situation, like if a potential beneficiary is suspected in the member's death?
Yes, the rules cover that. If someone eligible for the benefit is formally charged with the member's murder or abetting it, their claim is suspended, put on hold.
Until the court case is over.
Exactly. If they're convicted, they lose their right to that share, and it's redistributed among other eligible family members. If they're acquitted, though, their suspended share becomes payable to them.
Okay. And for those exempted establishments we keep mentioning, do they handle nominations differently?
They need to provide certified copies of the nominations their employees made under their own exempted fund rules. This ensures the beneficiary details are available even outside the main EPFO system.
Right, let's shift focus to the money itself. How is this huge insurance fund managed? Where is all that employer contribution money invested?
Good question. The EDLI insurance fund is invested following specific patterns notified under the main EPF scheme 1952. These patterns dictate where the money can go.
What kind of investments are we talking about?
It's a mix. Things like government securities, various types of bonds and debt instruments, some short-term instruments, also equity shares and related investments. Even things like certain asset-backed securities. But all within strict guidelines on credit ratings, percentages, etc.
So it's managed professionally, diversified. How do they make sure the fund stays healthy enough to pay out all future claims?
That's done through an annual valuation. It's critical. Because it's a collective fund, they need to assess its financial health. Is it sufficient? Is it solvent?
Who does this valuation?
The Central Board of Trustees, the CBT, appoints a professional valuer. The EPFO's pension and EDLI division and the IT division provide all the data needed for this assessment.
And what happens based on that valuation?
Well, the results can lead to changes. The government might adjust the employer contribution rate, that 0.5%, or they might revise the level of benefits paid out based on the valuation findings. It's about ensuring long-term sustainability.
So the benefit amount we discussed earlier isn't absolutely fixed forever.
Not necessarily. It has been revised upwards several times in the past, precisely because of these valuations showing the fund could support higher benefits. The government has the power to tweak contributions or benefits based on the fund's health.
Okay. Now back to exemptions. You said establishments can get exempted if they have their own good scheme. Can you elaborate a bit on those conditions?
Sure. An establishment can apply for exemption if they offer their employees a life insurance scheme that provides benefits at least as good as or better than the EDLI scheme. That's the main condition.
As favorable benefits.
Exactly. And their scheme has to meet other standards and conditions set out in the regulations. It's not automatic. They have to apply and prove it.
Who grants these exemptions?
The power has been delegated by the government to senior EPFO officials, usually the additional central commissioner at HQ or the zonal level.
And can an exemption be taken away?
Oh yes. If an exempted employer stops meeting the conditions or violates the rules, their exemption can be canceled. They also have specific duties if they decide to stop their own insurance scheme before the official EDLI exemption cancellation comes through.
The documents also mention other interventions. What kind of things are these?
These are sort of extra initiatives by EPFO to improve the scheme's operation.
Like what?
Well, there's a special procedure, an SOP, for settling claims faster when someone dies in an industrial accident. They even have a dashboard to track those specific cases.
That seems important.
Definitely. They also run campaigns, these e-nomination drives, pushing members to file nominations online because it really speeds things up later. And sometimes they do special drives to find and settle old, outstanding EDLI claims that haven't been filed for some reason.
Proactive settlement, okay.
And one more useful thing, the EDLI calculator on the EPFO website.
EPF calculator.
Yeah, it's an online tool. Nominees or family members can use it to get a rough estimate of the EDLI benefit they might be eligible for. Quite handy.
That calculator sounds very practical for families trying to figure things out. Okay, last point. What happens if an employer just doesn't pay? Defaults on the EDLI contributions or those inspection charges for exempted places.
There are penalties. The rules allow for recovery damages from defaulting employers.
Damages meaning fines.
Essentially, yes.
Yeah.
Financial penalties? The rates depend on how long the default period is, and the rates actually changed recently with different calculations for defaults before and after June 14th, 2024.
Is it automatic?
No, the employer has to be given a chance to explain. A reasonable opportunity to be heard, because imposing damages is seen as a quasi-judicial act. And on top of damages, there's also interest payable on the delayed payments under Section 7Q of the Act.
Right, so there are consequences for non-compliance. Okay, I think we've covered a lot of ground.
We really have. From when it started in '76, how it applies, who pays.
The contribution rates changing over time, the government's past role.
How claims are filed using Form 5IF or the CCF, the calculation of that crucial average balance.
And the benefit calculation itself, that dual formula aiming for the higher payout.
Who the beneficiaries are, the importance of nomination, especially e-nomination now.
How the fund is invested and valued annually.
Conditions for exemption, those extra interventions like the calculator and special drives.
And finally, the damages for default. It's a pretty comprehensive system.
It really is. And hopefully this deep dive has served its purpose, acting as that clear, accessible audio guide to the EDLI scheme based on the official documentation.
Yes, hopefully listeners now feel they have a much better handle on how EDLI works and its vital role in providing that safety net for families in the organized sector.
Absolutely. So maybe a final thought for listeners. As you think about all these details, consider the broader impact of schemes like EDLI. How do these social security nets contribute to the financial stability, not just of individual families, but of the workforce and the economy overall? Perhaps worth exploring how these regulations play out across different industries.
A great point to ponder. Thanks for joining us for this deep dive today. We'll catch you on the next one.